here, and this is a conference on Brexit, and it's my sincere hope that it will become totally irrelevant what we're going to say in 4 weeks' time. But we can't be sure about that. So we've got to prepare for all eventualities, and obviously if the UK does decide to leave, it will be an extremely serious matter, particularly for the legal profession. It will have enormous consequences. And the purpose of this conference is to detail some of those consequences so that we know what's going to happen. And for that, we've got an extremely able panel. Pretty well everybody who's an expert in this field. I'm very grateful that could come, and I'm grateful that so many of you were interested in it. And our first topic is the legal framework of the transitional period. And there would be, if we were to leave, quite a long transitional period with extremely complicated legal problems. And so we're going to hear from two experts about that. And the first one is Professor...
Can I just interrupt before you do that, Trevor?
Yes.
Sorry.
You want to put a little,
a
little advert in for the Institute?
Hey, he knows.
I did wait for you for a while, but then I didn't see any sign of you, so I thought you weren't coming.
No, you're brilliant to have started. I'm Robert McCorkett, Director of the British Institute of International and Comparative Law. Thank you for coming, and as Trevor says, please become members and come to all these great events. But my main purpose actually is to say a couple of thanks. Firstly, thanks to the Max Planck Institute in Luxembourg. I have very, very fond memories of going there, and in fact the circumstances was it hadn't started very long at all, and they put an event on the international rule of law, and rather foolishly they asked me to define the international rule of law, about which I had no idea, and so some or other conference nevertheless managed to go forward on that basis, and subsequently is now going to come out in a book and things like that. So it was fabulous, the kind of engagement and excitement that there is really at the Institute in Luxembourg. And I also want to thank Herbert Smith Freehills, who sponsored this series, which is great. And one other kind of warning. Of course, Brexit and Remain, or whatever one wants to call it, is of course a contentious issue. Everyone here is speaking in their personal capacities, and they are not advocating for one side or the other. Finally, I can thank my colleague Eva Line, without which none of this would happen. So I'm going to pass. Is there anything else I need to say? We're not expecting a fire drill. Pass it back to you, Trevor.
Okay, thank you very much. Well, I was going to introduce our first speaker, Professor Burkhard Hess. Many of you probably know all about him, but he's from the Max Planck Institute in Luxembourg. You know, Max Planck has migrated to Luxembourg, and they have an institute there for international European and regulatory procedural law, and obviously things like the Brussels regulation fall squarely within that remit. And he's also held chairs at various German universities, Tübingen, Heidelberg. He's been to Beijing, Paris, Georgetown, and various other things. I won't go through it all because it takes me quite a while, but now I'm sure you'd far rather hear what he has to say. So I invite him to make his presentation.
Thank you for this very kind introduction, Mr. Chair, ladies and gentlemen. I would like to say at the outset that the topic of this conference is not a topic which I do like. However, the uncertainty whether England will leave the European Union is a concern for all who believe in European integration and in the Union as a guarantor for peace, economic prosperity and freedom, which has been achieved since the end of the Second World War. If Britain leaves the EU, European integration will not end, but there will be a crisis on both sides of the Channel. And the rest of Europe will lose an important part of its identity. When debating technical issues of a Brexit, we should not lose sight of this broader perspective. On the other hand, if one looks at the current debate in Britain from the continent, especially when it comes to private international law, one might be surprised to learn that many commentators simply assert that the Brexit won't impact much on the situation as it is standing today. This is especially true when one looks at the websites of law firms practicing in the city. Usually, one finds the indication that there won't be many impacts. Conversely, one might be inclined to ask whether European private international law really matters, if it can be replaced so easily. This is one reason why we organized the seminar of today. We would like to explore the perspective of dispute resolution in London and on the continent in case Britain would leave the Union. You can find behind me the structure of my introductory remarks of today. I would like to start by giving you some hints concerning the state of affairs concerning cross-border litigation in London and on the continent. Then I would briefly like to address the regulatory framework regarding the transitorial regime, and I would like to address some practical consequences of the repeal quite briefly, because I know that this issue will be addressed later on. And then I would also like to look at possible solutions. Would it be possible for Britain to leave Europe but to come back through the back door by signing the Lugano II Convention, or by mirroring EU law by parallel provisions of national law? I'd like to start by addressing very briefly the role of London as a judicial market in Europe. And as you all know, London is performing very well compared to other places in Europe. There are some reasons for this. If we look at the main areas where litigation is attracted to London, we have, of course, the financial sector. We have maritime transportation disputes, patent litigation, cartel law is an emerging market. Divorce proceedings, London as a capital of divorce. I just read in the Times of today that there has been again a very important case decided by the High Court here. And of course, insolvency is also an issue. And the choice of London is very often made on the basis of European instruments, especially the Brussels I regulation, choice of court agreements, but also the special heads of jurisdiction are at the service of parties choosing London. And there are, of course, also reasons why London is performing so well compared to other places in Europe. Of course, there is English as the language of international business. There's the availability and expertise of legal advisors. And we have also to recognize that English procedural law is very attractive for commercial litigation. But I think there are also some factors which have directly to do with European Union law. And there one issue is that mandatory EU law is applied and enforced by English courts. And there is also the guarantee that judgments given in England will freely move within Europe and are enforced everywhere in all European member states. I have two statistics which shall demonstrate to you how successful London is, and I think these figures are quite telling. The first statistic is borrowed from a study which was made by the British Institute of International and Comparative Law almost 1 year ago. It's about the question, how are the numbers, the figures concerning foreign parties in the commercial court of London. And if you look at the commercial percentage of foreign cases, these are all cases which are not English and Welsh. So there are some domestic cases included which would be addressed differently in other EU member states. The last figure at the right-hand side is quite amazing. We have almost 50% of cases where both parties are not English and Welsh. Compare this with some figures from Germany. And I think here you can really see that the situation in other places in Europe is totally different. And just to make it very briefly, we have 1,140,000 plaintiffs in local courts. And if you take up the figures where foreign parties are in these proceedings, so it's a very, very small percentage. It's 1% up to 2%. It's not more. And we are talking about courts as Cologne, Frankfurt, Hamburg, and Munich. And there are international businesses doing their affairs there. But the cases, quite often, and just look at the names of the parties which appear in the judgments of the High Court, the Court of Appeal in London, they select London. So this is the state of affairs today, and my question is, will it simply continue when Britain votes for the Brexit? That's the issue of today. Well, if the Brexit is successful, let's now look at the legal framework. Let's look at the divorce regime. I don't have to explain this very much in detail because I suppose that this provision is now very often discussed here in England. And the Lisbon Treaty provides in Article 50 the possibility that a member state also leaves the European Union. If Brexit is voted successfully, then there will be a transitorial period of 2 years. During this period, an international agreement between the Union and the United Kingdom has to be negotiated. In case that these negotiations fail, and you should be aware that European Parliament has also a say in accepting such a transitorial regime, then there is a time limit of 2 years. Then there won't be any regime. It will simply be over. Maybe there is a possibility to prolong this time, but that's it. My next ideas, or my next slides, address this situation, that we don't have a transitorial regime. We don't know whether this might happen. It might be in the interest of all parties involved, but what I would like to say here quite clearly is this will also be an emotional issue on both sides. So don't expect that on the side of the European Union there will be much, let's say, engagement to start immediately negotiations to come to the best solution. Maybe people refrain for a while because they say, well, we have never had the situation, now we have to see how Europe will perform and continue its own path. So what will happen if Brexit becomes effective? These are the instruments of the European law of civil procedure and private international law, which will be repealed. It's of course the Brussels I regulation, which provides for the free movement of judgment within the European Union, and all specific instruments on mutual recognition, which even implement the recognition regime more intensively. The Brussels II bis regulation on cross-border divorce and parental responsibility, the insolvency regulation, which is performing quite well also with regard to the United Kingdom, service and evidence regulation, the new EPLA regime, patent litigation agreement regime, which provides for the jurisdiction of English courts in the first instance for the European patent courts, not only London, but nevertheless, it is one major place. This has to be changed. And of course also private international law, the Rome I and Rome II regulations. So what will be the replacement? Can we go back to the Brussels Convention? Well, one might argue that the Brussels Convention had been repealed by the Brussels Regulation. If the Brussels Regulation ceases to exist, one might say, well, Brussels Convention will come up again and be applicable. Frankly spoken, I doubt on this. There are several arguments against it. One might be derived from the Vienna Convention of the Law of Treaties. So you might see Article 53 of the EU Treaty, I just showed it to you, as a specific regime which says that all conventions which had been concluded in the context of the European integration, and the Brussels Convention was of course an instrument of European law, shall be terminated or are terminated by the consent of all contracting parties. And there is also an argument which is derived from European Union law. As you know, this convention was interpreted by the European Court of Justice according to a protocol. And I don't see a situation where the convention is still applied, but the protocol is not. So I don't think that going back to the Brussels Convention will be the solution, but we can discuss this. Another possibility might be to go back to 6 former bilateral conventions on the recognition of judgment, which were concluded between the United Kingdom and some other European states. I don't go into the details here, but I would simply like to stress that there are several disadvantages. One disadvantage is the regime foreseen by these conventions is outdated since the 1960s. Just to take up one example, the convention between the UK and Germany is applied in a way that a creditor who has a judgment obtained in the UK and who wants to enforce it in Germany has to go to the German court and to start litigation again. So this is not free movement of judgment. This is really the Middle Ages of private international law. And there are some additional impediments here which I don't want to address in detail. Let me go one step further. One might say, okay, this is not the right way, but there is still the famous Lugano Convention, which has been reformed in 2012, if I'm not wrong, or 2007? 2007, yeah. And this is a modern instrument, and the UK could simply sign in. Just join the EFTA, and according to Article 71 of the Lugano Convention, every EFTA state has a right to sign into the Lugano Convention. There won't be any discussion according to that article with the European partners. It's simply foreseen by the convention. So again, here are some issues to be considered. One issue is joining EFTA might not be an easy way. Second issue, the question is whether this provision was really meant to be applied to an enlargement of EFTA to states who finally do not want to become members of the European Union. The old approach was the opposite one. If this provision does not apply, then there is still the provision of Article 72, according to which the UK may sign in, ratify, then Switzerland has to verify whether the United Kingdom corresponds to the human rule of law standards of the convention. This might not be an issue, but in case the Brexit is also applied to the European Convention of Human Rights, it might become one. And finally, it's also up to the European Union to consent to this ratification. So there is still some doubt on the Lugano II Convention. And finally, it has to be said, if Britain joins the Lugano Convention under these circumstances, then the European Court of Justice will interpret this convention, and there won't be any judge from the United Kingdom. The government of Her Majesty has a right to give an opinion in the cases, but that's it. So the binding force will be unilateral, and maybe we learn or we hear something from Tanja Domay concerning the Swiss experiences with Lugano, which were, as far as I have learned, at least a little bit mixed to some extent. I just came back from New York and I talked a little bit about this issue also with my American colleagues. And one proposal they made was, they told me, well, Britain might also go another way. It might be possible to enact legislation which comes very close to the European instruments. In this case, there shouldn't be many impediments according to the autonomous laws of EU member states when it comes to the recognition of judgments coming from Britain, because the same standards are more or less applied. So just align national law to European instruments, and then you can guarantee to some extent that the free movement of judgment will continue. Well, this will depend on the autonomous laws of 27 different EU member states. And we should not be too sure that they will be all so receptive as expected. I would like to give you two examples which have been enacted within the current EU framework, and as you may know, the United Kingdom is not fully integrated in the process of European procedural law, and there is always an option to opt out from some European instruments. Just to give you two examples, one comes from insolvency and the other one from the regulation on the cross-border attachment of bank account. In the insolvency recast, there is one issue which has been very, very intensively debated. And this is the famous scheme of arrangement and the question to what extent it can circulate under the insolvency regulation or under the Brussels I regulation. Under the insolvency regulation, according to the recast, it's up to the member state to communicate to the European Commission which national instruments qualify as an insolvency procedure and which not. And the UK government has not communicated the scheme of arrangement as an instrument which is an instrument of restructuring and insolvency, because the government said this is an instrument of company law. However, one can debate this at least. And the reaction of the Parliament in the tripartite negotiations was quite clear. They were aware of the problem, and they inserted in the recital number 7 a last sentence, which says, even if a national instrument is not communicated to the European Commission as being part of the insolvency regulation, in brackets, but it might be one, then there is no binding force that this instrument may circulate under the Brussels I regulation. And this is a kind of, let's say, retortion from the side of the European institutions. And the second example is even more explicit. It's about the regulation on the cross-border attachment of bank accounts. Here, the UK government negotiated over years with the Commission within the Council about its adoption. Finally, Britain declared its opt-out. It was entitled to do that. But the reaction of the Parliament was again quite clear. They included in the recital saying that creditors domiciled in member states which do not participate in this instrument are not entitled to make use of it. So I attended a conference in Trier, and some English colleagues discussed this with us, and they said, this is a discrimination. They said, yes, of course, it is. But you are not in, so you are out. And the reaction is negative. So I'm a little bit explicit here, because this is a topic which I consider as very important. And as I told you, I would really like to see Britain staying in the EU. We have to get a lot from you, but be aware, in case you go out, Brexit is about a divorce. And a spouse seeking a divorce should not expect much generosity from the person he or she is leaving. Thank you very much.
So who would like to ask some questions? Yes.
I just wonder, because I have been thinking about the use of our London court by foreign litigants, and it's quite clear, we know from various studies that the figures are quite high. What I couldn't find, and what you didn't show, was a breakdown of those foreign litigants between EU and non-EU litigants. I wonder if you have any information on that.
As far as I know, it does not exist, unfortunately. This would be very helpful. The Luxembourg Institute is just conducting a big study for the European Commission regarding the differences of national law and their impact on the free movement of judgments and mutual trusts. And the Commission asked us to collect statistics in all member states, and we are always happy if we only get these statistics. So they do not exist for all EU member states. We are quite happy if we can distinguish between domestic and foreign litigants. Nevertheless, if you look a little bit at the names of the parties who are here in London, my guess would be at least up to 50% of foreign litigants are from other EU member states. Maybe even more.
Yes, of course. Also, even if the parties are not from the EU, if you have a Kuwaiti and a South Korean, the EU element could still be very important, because the Kuwaiti might have chosen London because he wants the judgment to be enforceable in Italy, say, where the South Korean has assets. So the EU element would exist. Who else wants to ask a question? Yes.
You included Rome 1 and Rome 2 in one of your slides, but would you agree that they're a different case when it comes to the UK's ability to create its own legislation which effectively mirrors what it's got already?
I would say I'm not the best expert to discuss this here at the table. This is rather Andrew, who is much closer to these instruments. There's certainly a difference between instruments of private international law and of international civil litigation. In this respect, I do agree, especially as the review of foreign judgments is not combined with a review of private international law applied under the Brussels I Recast regulation. If you go back to the old instruments and to the autonomous laws of EU member states, it might be different. Germany has it given up, but there are, even under the old bilateral treaties, there are some of them which explicitly provide a review of the application of private international law in the member state of recognition and enforcement.
And do you want to add anything to that?
I'll add something during my talk.
Yeah, okay, fine. So, maybe, but I mean, clearly there's a difference, because the UK could obviously pass a law saying that whatever, that Rome 1 is English law, and for what it's worth, that would then be English law. How important that would be for litigants, I'm not so sure, actually. But anyway. Yes, a question from there first, and then you after him. Yes.
Sorry, about the percentage you showed about the foreign litigation in the London court. This all percentage about the party autonomy ground of jurisdiction or other grounds of jurisdiction? I mean, in the other way, the percentage would show about the foreign litigation in the London court. This all came under the party autonomy?
If you have two foreign parties coming from outside of the United Kingdom, then you need a choice of court agreement to come under the European instruments. If you have a defendant domiciled in Britain, then it's easy. On the other hand, if you have a party domiciled, defendant domiciled in another EU member state, the regulation will apply, but you need a specific head of jurisdiction. So there are many cases which are presently covered by the rules of the Brussels I Recast regulation.
And of course, the judgment we recognize even if the jurisdiction was under national law, and that's a very important rule, I think. So if we have the Kuwaiti and the South Korean, and they come to England on all sorts of grounds, and maybe take jurisdiction under English law, some rule of English law, like the contracts governed by English law, the judgment will still be recognised in Germany under the regulation.
But unfortunately, it will not recognize in Kuwait.
That's you know Kuwait. Yeah. Well, that's a different matter. Yeah. You could maybe tell us about that. There was a question.
Yeah, I wondered if I could just interrogate you about slide C1, practical consequences of a repeal and the Brussels Convention.
Yeah.
Two questions. First of all, you say under international law, a treaty not entirely superseded may revive when a later treaty which replaced the former one is repealed.
Yeah.
Is that just a general principle, or do you have a particular case in mind? That's the first question. And the second question is, in the last sentence, you say that the argument that doctrine would apply might not apply because Article 50 sub 3 of the EU treaty operates as termination of the Brussels Convention. But if England has left the EU treaty, then that operating as a termination would seem no longer to apply. Those are my questions.
Yeah. Thank you. So I refer to the Vienna Convention on the Law of Treaties.
Right.
Yeah?
Yeah.
My first point is what happened to the Brussels Convention the moment when the Brussels Regulation entered into force. It was not entirely repealed because it still applies, as the Convention still applies to some overseas territories which are not part of the European Union. So it is still in force. In this case, according to the Vienna Convention on the Law of Treaties and General Principles of International Law, I don't refer to specific case law, there is not much. Yeah? Then one might argue that the convention is still operating and it can revive in the sense that it enters now into force between those member states who were or are already bound by it. Not a very strong argument to my opinion. And then the second argument is, well, the Vienna Convention on the Law of Treaties provides that states may always, convention parties may always agree on a specific termination of a treaty or withdrawal, something like this. And this is foreseen in Article 53 of the EU Treaty, which has to be, to my opinion, interpreted in that sense.
Yes, put that lady there.
Even if we could go back to the convention, that is like going back to the Middle Ages, the Dark Ages. We've at last done our amendments in the recast, and of course...
I do agree, and in addition, my question would be, are the other member states of the European Union required to set up again the implementation legislation to the old convention? I don't see it.
Yes.
Yeah, sorry, this is more of an observation question actually, but it may be Professor Hardy's present on the panel. But I think one other way out for the UK would be possibly to ratify the Hague Convention on choice of course agreements independently, because then if we become a Hague party, then naturally for the cases which fall within the somewhat limited scope of that convention, the recognition of force.
I do agree. If you look at the Hague Convention, you will see there are many, many exceptions. Yeah. So it will be a very limited way out. Yeah, but this might be one option. Yeah.
Yes.
Yeah. Maybe one very short remark relating to the old Brussels Convention. I think there's very, very, very compelling evidence that no country can be a party to the Brussels Convention that is not a member state to the European Union. If you look at the history of the Brussels Convention, it was based on the old Article 220 of the EEC Treaty. Only those countries who were bound by that provision could join and could be a member of that convention. Secondly, if you go through the recitals of the convention, it clearly follows and pursues the purpose of making easier the free flow of judgments and the jurisdictional system within then the community. There's very strong evidence that you have to be a member of then what was then the community in order to be a party of that convention. It's an implied condition. I can never ever imagine that any other member state would even accept discussing the idea that the old Brussels Convention could revive. I think that is absolutely out of the question. That was very strong, but I'm quite convinced.
Tanya Lomé was, I think,
I would agree, because Switzerland originally wanted to join the Brussels Convention. It was not Switzerland's idea to have a separate Lugano Convention, but the Lugano Convention had to be created as a parallel regime to the Brussels Convention exactly for this reason, that the European community always said it's not possible for a non-EC country to be a party to the Brussels Convention. And if the EU says we're not going to apply it, I mean, how will the UK force the EU to do that?
Okay, I think that person's next, and then you can be after. And I think maybe we should then move on to our next speaker after those two questions. Yeah.
I was just going to observe in response to what's just been said that the Dutch Caribbean island of Aruba is party to the convention, and it's not a member of the EU.
Yeah, but it belongs to the Netherlands. If the UK would join or exceed another member state, it might be possible, but probably that is not what the Brexit is all about.
Okay, I'll ask a question.
To come back, because the point was, of course, the UK was a party when it acceded to the Brussels Convention, so that isn't really an answer. The question is whether it springs back into life in respect of somebody who was a party when they did sign it. So it's not the same as Switzerland at all. It's completely different because Switzerland was never a part of the EU.
Well, there's also the question: who will decide? Will it be the CJEU or the ICJ? Anyway, well, we've had a fascinating discussion.
Thank you. I must begin with a confession and say that I'm not quite sure what this has to do with validity in the technical legal sense. I'm actually going to change the title, if I may, with apologies to the organisers, and say enduring effectiveness. And the point of that distinction may become apparent as we go through. I need to begin with some preliminary remarks. First of all, some preliminary remarks about these remarks. First of all, I mean, despite the properly inclusive nature of the title of this conference, I'm going to focus very much on litigation in London, but I'm not going to confine myself exclusively to problems concerning English jurisdiction agreements, because, of course, jurisdiction agreements affect litigation in London, whether they are in favour of the English courts or not. Secondly, I want to make it clear that my task is to identify the implications for jurisdiction agreement for the validity and effectiveness of such agreements if Brexit occurs, given the alternatives. You shouldn't regard any of what I say to be an argument for Brexit, just in case that impression might be given. Importantly, the next point to make is that in discussing the various alternatives concerning jurisdiction agreements, of course, we can't really investigate this problem in isolation, because what we're talking about, of course, is the optimal regime to govern jurisdiction and the enforcement of judgments. Generally, it's, in a sense, rather unreal to take jurisdiction agreements as a subset of that. And of course, as has become very apparent in the fascinating discussion that we've just had, everything really turns on what the overall Brexit strategy is going to be. It depends on what the Brexit model is going to be. Are we going to be Switzerland? Are we going to be Norway? Are we going to be Albania? I must say, as a private international lawyer, I'm rather struck by the fact that no one is suggesting that we should be utopia. Ostensibly, my concern is going to be with the technicalities of how we regulate jurisdiction agreements under the possible new regime, but of course I'm very mindful of the elephant in the room, the underlying issue to which we're going to return in the final round table, and that is the all-important question of what difference is this going to make to London's dominance in the market for the resolution of international commercial disputes. I need also to make two general observations of a more technical sort. The first is that there is, of course, another elephant in the room. In fact, I suspect there are several. That is arbitration. I'm going to be talking about jurisdiction agreements, but of course one consequence in the post-Brexit world may be further to accelerate the move towards arbitration, at least as an alternative mechanism to civil court resolution, as a way of dealing with commercial disputes. If you do that, of course, then you're free of all the questions that I'm going to be discussing. You're simply in the territory of the New York Convention, which of course operates in all the EU member states, and none of the problems that I'm about to discuss would arise. It's important also, I think, just to say a moment, just take a moment to examine what it is that jurisdiction agreements are meant to do, because in a way this colours everything about this debate. The purpose of a jurisdiction agreement, of course, is to reduce and, if possible, remove risk. They are intended to deal with litigation risk. They are intended to ensure that a dispute will occur in the optimal forum for the parties, or more commonly, of course, in the case of financial transactions, one of those parties, namely the finance party. They're also intended, of course, to ensure not simply that you end up in the right place, but that you can assert your rights in that place without a lengthy dispute about jurisdiction. That's to say, a jurisdiction agreement also has to be litigation-proof. Finally, of course, the point about a jurisdiction agreement, and this is especially important in this context, is that they are intended to reduce a subspecies of litigation risk, enforcement risk. One of the reasons, perhaps a dominant reason, for selecting as your court of choice a particular forum is to ensure that by doing that you are buying into the enforcement of any judgment obtained there elsewhere, and that of course has obvious consequences in the context of the EU. So essentially what I want to do is first to set out very briefly the current position to see what we would lose, and then turn to the nub of the matter, which is to consider the post-Brexit alternatives. As to the current position, well, we all know what this is, but I think it's important to realise how good it is. First point to make. Under the current scheme in Brussels I bis, we know that English jurisdiction agreements are well protected. Article 25 ensures that such an agreement is effective to confer so as to confer jurisdiction on the English courts, and also to deny jurisdiction to any other EU national court, and it does that very clearly. Article 25 also, of course, solves the old riddle of validity, the old chestnut about what law would govern the substantial validity of a jurisdiction agreement, which used to afflict the predecessors of Article 25. Again, although I know we could argue about this, Article 31(2) effectively, if perhaps not absolutely entirely, solves the old Gasser problem. So we are basically currently in a good place. There are difficulties. There are difficulties about the compatibility of asymmetric jurisdiction agreements with the regime. There are difficulties about the precise operation of Article 31(2), which of course is notoriously badly drafted and leaves open a host of procedural questions, and may indeed not entirely remove the difficulty of preemptive forum shopping. But in principle, they are marginal problems, and they can be solved. Although I should of course admit at this point that if they are to be solved, they will be solved by the Court of Justice, and I think we need to come clean and say that that is not a judicial body which inspires the confidence of English commercial lawyers. It's also worth saying that some of the difficulties with the current regime are exaggerated. For example, in relation to asymmetric jurisdiction agreements. Some law firms are already solving the problem by a sort of self-help mechanism by simply not inserting asymmetric jurisdiction agreements in their documentation at all, because of course a straightforward vanilla exclusive jurisdiction agreement would solve that. Of course, English lawyers identify a deeper problem, the problem that, in the world of the Brussels regime, we cannot use our beloved anti-suit injunctions to enforce swiftly and in our own court an English jurisdiction agreement. Yes, but in the world of Article 31(2), I suspect that that is perhaps itself a rather marginal problem. So I think marks out of 10 when it comes to the effectiveness of the current regime in relation to English jurisdiction agreements, I would say 8. Equally, of course, the current regime ensures that jurisdiction agreements in favour of other EU states are respected in English proceedings, and we should not forget that fact. it being the converse of the points I was just making. Again, of course, the current regime, if we think beyond Brussels I, introduces important degrees of procedural certainty for the parties to English jurisdiction agreements. This procedural certainty, of course, is of benefit to anybody who comes before the courts of an EU member state. But the point is, you may, even though you have no connection with the EU as a party to a contract, volunteer for these benefits, simply, of course, by agreeing to the jurisdiction of the English courts. These procedural benefits are, of course, the ease of service of process, subject to the process regulation, and, of course, importantly, crucially, the certainty which exists in relation to the enforcement of judgments. Those are benefits that you buy if you agree to the jurisdiction of the English courts currently. Of course, English lawyers would nonetheless identify a real point of difficulty, and it is a real difficulty in relation to the treatment of jurisdiction agreements in Brussels I, and that relates to the status of jurisdiction agreements in favour of non-EU states. This is not the moment to debate this in any detail, but of course there is considerable uncertainty about the operation, about the scope, about the exclusivity of Articles 33 and 34 of the regulation, which introduces profound questions about the ability of the courts of member states to give effect to a jurisdiction agreement in favour of the courts of a non-member state. Again, that might be solved by the Court of Justice at some point, but again, I express my hesitation in having confidence as to what they might do, certainly in terms of commercial efficacy and certainty. So the interim conclusion, which I think we need to arrive at if we're going to look at the alternatives, is that on balance the current regime succeeds in the context of intra-EU disputes. It may be defective, and indeed seriously defective, in the context of disputes involving non-EU jurisdiction agreements. But, having said that, if we're concerned, we shouldn't be concerned primarily, but if we are concerned with the effectiveness of English jurisdiction agreements, then of course that second point is not so important. So, where would we be without this regime? What are the alternatives? I'm not going to traverse again the interesting ground that my colleagues tackled in their earlier presentation. I'm simply going to make the point that I take for granted that these various options, these various models exist. What I'm going to do is to pretend that the alternatives that I'm going to describe are simply straight alternatives and do not depend, as they do depend, on what the post-Brexit model will be. I should also say, of course, that these are, in an important way, not straight alternatives, because as we shall see, if one were to go down the Lugano route, or heaven forbid, the Brussels route, that would, of course, still leave room for English national law to apply in those areas to which the regulation does not, because they do not represent, in relation to exclusive jurisdiction agreements, an exclusive regime. So, what are the options? First of all, there is the unilateral approach. One approach on Brexit Day +1, as it were, might be that we simply default to the common law rules. Oh, paradise lost, the Garden of Eden. One cannot help feeling a twinge of hope that this might be the way forward. English lawyers would see here, of course, a return to welcome flexibility, and they would see here also the resurrection of the ante-suit injunction as a mechanism for giving effect to jurisdiction agreements. There are disadvantages with this approach. There is a degree of uncertainty, but as anybody familiar with the English approach to jurisdiction agreements will know, there is actually a much greater degree of predictability than I think people sometimes suppose. If there is a difficulty, it is of course not the difficulty, I think, that a jurisdiction agreement, English or foreign, certainly if exclusive, would be enforced. It's the difficulty that to assert that right, you have to spend a great deal of money and go to the commercial court and have someone answer that question for you. There is, of course, the possibility under this approach of the revival, again, of the ante-suit injunction, though that might be a marginal gain, considering that on the current on the current position. So I think the sub-conclusion would be, under the first of the unilateral options, that's to say default to the common law rules, jurisdiction agreements are protected, if not perhaps with a degree of certainty that one might wish. Another unilateral option, of course, is to adopt new national legislation regulating jurisdiction so as to fill the gap. We would simply have a new jurisdiction statute. We wouldn't default to the common law rules, we would have a new regime. What I have in mind here, of course, is a regime which would reflect the certainty that we currently have under Article 25. I'm not suggesting a discretionary approach to jurisdiction agreements, certainly English jurisdiction agreements. I'm suggesting a mandatory approach, which simply gives us back the certainty which we would lose if Article 25 were no longer to operate. But the advantage of this approach is that it would, of course, give us some freedom to solve the difficulties that arise in relation to jurisdiction agreements and to improve upon the Brussels regime. Perhaps there's no need to have a legislative provision in such a regime to solve the problem of asymmetric jurisdiction agreements because they are in any event valid under English law, but nonetheless that possibility remains. The English court would of course be allowed to grant anti-suit injunctions again. And of course, no problem would any longer arise about how to deal with a jurisdiction agreement in favour of the courts of non-member states. So I have to say, there is a lot to be said with the new jurisdiction statute. I know some people would say there's a disadvantage that such an approach is unilateral. It does not guarantee, of course, that the English jurisdiction agreement will be given effect in the courts of other EU states. And it is, of course, the case that the effect which might be given to such agreements would have to depend on the national law of other member states. But I have 2 points to make about that. First of all, at least in relation to English jurisdiction based on jurisdiction agreements, it is surely the case under the national law of many other member states that effect would be given to those agreements. One only has to think of those French cases where they have given direct effect to English anti-suit injunctions in the old days when such things were possible in this context, provided they gave effect to English jurisdiction agreements. In any event, any difficulty is presumably diminished by the possibility that since we're now back in the world of the common law, the anti-suit injunction could be used as a mechanism for enforcing the English jurisdiction agreement in the event of preemptive proceedings elsewhere. Again, we've touched already on the problem in any such unilateral regime that there is no guarantee that a judgment given in the English courts would be enforceable in other member states. But again, one has to ask the question, leaving aside the possible revival of bilateral treaties, would that necessarily be the case if we were talking about an English judgment given on the back of an English exclusive jurisdiction agreement? I suppose the point I'm making here is that there are attractions to this approach. There may be disadvantages, but the attractions, I think, deserve scrutiny. Of the multinational options, I'm not going to rehearse again the various different models and possibilities that exist. I'll simply make this point, that at least if we look at the Brussels Convention as we know it, the Brussels Convention, and at least if we look at the Lugano Convention in its current form, it is, of course, an unattractive solution to say that we should resort to those as the way forward, simply because, if we take the example of the Lugano Convention, of course, it suffers from the defects of the old unrecast Brussels regulation in relation to jurisdiction agreements. That's to say, it is partial in its approach, that's to say it doesn't apply to all jurisdiction agreements, and of course it preserves all the vices associated with preemptive forum shopping in cases like Gassa and JP Morgan. There again, there is the Hague Convention, which of course has some attractions as between the UK and other EU states, but of course it suffers from the fact that its international scope is perhaps not something that we can take for granted. It may not be a solution to the other problem I mentioned, which is the problem of third state jurisdiction agreements, given the possibility that it will not have the universal scope that perhaps those who drafted it might have hoped. So what conclusions are possible? Well, I suppose we can say that resort to the old common law is relatively unattractive, but it still offers protection to jurisdiction agreements. The multinational options, that's to say, perhaps going down the Brussels route, the Lugano route, and so on, have certain attractions, but I think we have to take Burkhard's point that we cannot guarantee that we will be allowed to go down that route in relation to any of those instruments, and if they are to be options at all, one suspects they are not short-term or even medium-term options. Set against that the possibility of some sort of unilateral legislation along the lines that I've suggested seems attractive. It may also, incidentally, be particularly attractive if we do go down, say, the Lugano route, because the Lugano route, in relation to jurisdiction agreements, will, of course, still leave space for national law to apply, and there may be some case for bringing our national law more into line with the European tradition in terms of the certainty and enforceability of jurisdiction agreements. I suppose the point to make here is that whatever the pros and cons of the different routes, under any of these possible heads, leaving aside the practicalities, leaving aside the technicalities, under all of these routes, at least as regards the protection of jurisdiction agreements, I think we can conclude that jurisdiction agreements would be protected. There would not be, in relation to jurisdiction agreements, as it were, an effectiveness vacuum. And in that sense, I think one can conclude that in relation to jurisdiction agreements, Brexit may, at the end of the day, not have the catastrophic consequences that some people may suppose. But there is, if I may say, in final conclusion, a different problem. All of us in this room can probably accept this conclusion. But the difficulty is not that there would be no legal vacuum. The difficulty is the uncertainty, or should I say the perception of uncertainty. That is the difficulty. If I were to make any practical suggestion, it would be that in the event of an out vote, that we ought to make it clear at the outset in the United Kingdom that we will at least legislate unilaterally on the lines that I've suggested, not necessarily as an exclusive option, but as a way of making clear that from day one, as it were, an English jurisdiction agreement at least will have the effects that it would have had under Article 25. The importance of that, of course, is that there is a strong message that on day zero there will be protection for jurisdiction agreements. There is the message that even if the UK were to adopt, as it were, a strong unilateralist Brexit model, that even in that scenario such agreements would be protected, and it would also bring into line, if we were to go down the Lugano route, as it were, the European approach, if I could describe it that way, and the English law approach. So I suppose the final conclusion should be that if Brexit were to occur, things may not be so bad, after all, when it comes to jurisdiction agreements. In fact, it's possible they may even be better.
Thank you very much.
What you heard so far was pretty much a look at our topic from a bird's eye perspective, and I would have loved to contribute to that bird's eye perspective as well. However, unfortunately I cannot avoid tormenting you a little bit with these hard and maybe also petty doctrinal problems that arise or may arise in relation to the enduring, however you call it, effectiveness, validity, or whatsoever of choice of court agreements. In the world of contract law, most national legal systems follow the good principle that the validity and effectiveness of a contract is determined according to the laws applicable at the moment when a contract is concluded. That lets us all sleep safe and sound. Once a contract is valid, it remains valid even if the legal system changes. And what I'm going to talk about is that the same under the Brussels regulation? I don't know whether the political process in the UK has developed a denomination for the day we are talking about. I have to decided to call it the B-Day, whatever. And I hope you forgive me as a German that chose that, whatever that means. So the question is, what happens to choice of court agreements that have been concluded either between 10th January 2015, when the Brussels Recast became effective, or 1 March 2002, after the old regulation became effective, and B-Day? What happens to those agreements? If we could, and of course, we could also add the time of the convention to that. If we could simply transfer the rule that we know in most contract law systems, validity determined according to the laws valid at the time or in force at the time of conclusion, then everything would be easy. A choice of court agreement concluded before or prior to B-Day would be valid if it was valid under the old regulation. What I'm going to talk about is why and in how far that is not the case under the Brussels regime. Yeah, as a civil lawyer, I always start with what we have in an applicable or maybe applicable provision. In our case, this is Article 66 of the Brussels Recast, and it says that the regulation shall apply only to legal proceedings instituted and to agreements instituted after 10 January 2015. Basically, that provision has a positive effect. It means even if a choice of court agreement has been concluded prior to 10 January 2015, if the proceedings commence after that date, the regime applicable is the Brussels Recast. And the example tells you what that means. For instance, if you have an Australian and a Canadian party who have agreed on London as their place of jurisdiction in 2014, when the old regulation was still applicable, that would have resulted in the inapplicability of Article 23, because under the old Article 23, one party had to have its seat in a member state. So when that agreement, that hypothetical agreement was concluded, the old regime would not have been applicable. However, if the proceedings commence after 10th January, the new Article 25 is applicable, Brussels Recast applies. That is what Article 66 tells us. The question now is, what is in the opposite situation? The opposite situation means we have an agreement that is concluded at the time when Brussels Recast is applicable, but the proceedings only commence after a hypothetical B-Day. Do we have an inverse application of Article 66, subparagraph 1, or do we have enduring validity under some general contract law principles? Well, we have some case law. I think the most significant case in this respect is the Sani Central case, and in its paragraph 6, the ECJ, paragraph 6 of the decision, the ECJ says that a clause conferring jurisdiction to a certain court only, and I think the English translation of the French original is not quite correct here. only gives you an option. And the ECJ says this option does not have any legal effects. I'm not sure whether this is correct, but the ECJ says so. Does not have any legal effects for so long as no legal proceedings have been commenced. If you take that seriously, it's quite clear that the general principle of Article 66, subparagraph 1, results into the conclusion that if we have a choice of court agreement concluded prior to B-Day and the proceedings commence only after B-Day, then we don't have guaranteed enduring validity under Brussels I bis. However, Sanit Central does not directly address that situation. Sanit Central is a case where the regular situation of Article 66, paragraph 1 was at stake, so it's not a direct answer to our problem. However, we do have some additional national case law. For instance, and we do have the Wolf Naturprodukte, which also is a very important case. Wolf Naturprodukte relates to the question, what do we need in situations where recognition is at stake? And it says, Wolf Naturprodukte says that in order to have the Brussels regime applied to recognition, both concerned states, which means the state of the judgment and the state of potential recognition, need to be member states when recognition is at stake. I think that supports the general idea that there is a principle that the Brussels regulation only applies between two states if the Brussels regulation is in force at the relevant moment in these two states. However, Wolf Naturprodukte only addresses a certain situation, so it's not complete, it's not compelling evidence, but it's a very strong argument. And we also have national case law. The national case law we have relates to, and we'll give you two examples, relates to the problem, what happens if a choice of court agreement was concluded prior to the entry into force of, in this case, it was the Lugano Convention, but it also applies to all other instruments. What happens if initially the choice of court agreement was valid and then Lugano, or maybe Brussels, entered into force and Brussels or Lugano stated additional requirements for that agreement. And the Landgericht München, in that case, said, well, as we can see from Article 66 and Sanit Central, the relevant moment is the moment when the proceedings commence. Even if initially the agreement was valid, that does not help, because when at the moment the proceedings started, the agreement does no longer meet the necessary requirements, we don't have a valid agreement. And that's not only the Landgericht München, it's for instance also the Supreme Swiss Federal Court, which has decided in the same sense. So there's a very strong argument that there is no general principle that choice of court agreements, if they once are valid, remain automatically valid. And I think indeed these decisions are correct. There is, of course, on the one hand, the argument, the contract law argument. There's an agreement, parties trust in the validity of the agreement. In general, this deserves to be protected. However, the problem with jurisdictional agreements is that under the Brussels and also under the Lugano, but under the Brussels system, there is a very close link, a very close connection between the jurisdictional rules and the lis alibi pendens rules and the rules on recognition and enforcement. And this is why we need to have all these three regimes, which are so closely connected, to be valid at the relevant time. And therefore, I think we have to say these decisions are correct if the Brussels regulation is no longer in force in the moment the proceedings commence, then it doesn't guarantee its enduring validity. So what we have for the Brexit scenario is no rule under the Brussels regime that validity at the time of conclusion is preserved when the law changes. We have the principle that jurisdictional rules do not automatically apply without application of the rules on lis alibi pendens and recognition. And in my view, the conclusion is that the Brussels regime is no longer applicable after Brexit in relation to the prorogation effect of agreements. The validity is a matter of the successor regime. You see from, or you hear from what I have said, that the situation might be different for the derogation effect, because even if the UK leaves the European Union, the Brussels regulation will remain valid in all other member states. So the question is, will all other member states continue to apply the Brussels regulation on that agreement? Unfortunately not. We have a decision on that problem in the Codec case and Codec Maritime, and it says that the convention does not apply to clauses designating a court in a third country. A court situated in a contracting state, and the same applies to the regulation, must, if seized, notwithstanding such a, assess the validity of the clause according to the applicable law, including the laws, conflict of laws rules where it sits. So under Codec, also for the derogation effect, the successor regime applies. There is only, I think, I'm aware only of one very narrow exception, and that is the Ahmed Mahamdia case, which concerned an employment law, employment contract disputes. And you may have in mind that Article 21 says that for employment contracts, there is a mandatory forum at the seat of the employee, but that the parties can agree to the additional competence of another forum in favor of the employee. And if that other forum is located outside the union, then, that is what the decision says, then for that very particular situation, the regulation does apply. Does that have any relevance for commercial disputes? Not very much, I think, because that only applies in relation to those heads of jurisdictions that have that the structure that we see in employment contracts. And that this is only the case in relation to employment and consumer contracts, and to a certain extent to insurance contracts, because for some strange reason EU law treats the insured, however big the company is, like a very, very weak party that deserves some protection. So in that case, the Brussels regulation may still be relevant after Brexit if the parties agree on an additional forum in London. But in general, it will no longer be valid, applicable. That does, of course, not mean that all agreements become invalid. As I said, their validity depends on whatever the successor regime is. However, we do not longer apply what Brussels gives us in relation to choice of court agreements, which is formal requirements of conclusion, minimum requirements of contractual, in relation to contractual consent, the choice of law rule, Richard Fentiman has talked about that, and the interpretation of agreements. And that applies in relation to both, in relation to prorogation and with very limited exceptions to derogation effects. And furthermore, the jurisdictional guarantees, exclusive application of headings of jurisdiction and exclusion of certain fora no longer apply after Brexit. That does not necessarily say that, or mean that the Brussels regime is superior to whatever comes after that in the hypothetical case of a Brexit. It only says, in this respect, it is not longer available to these agreements. That is what we know, and yeah, everything else depends on what will be decided in the referendum and in potential negotiations afterwards. Thank you.
Well, now we can have questions put to both speakers. And who would like to ask? Yes.
In relation to the presentation by Richard about the use of anti-suit injunctions, do you not think that the fact that the anti-suit injunction will be used to protect choice of forum agreements, and then I can see that it would be even more difficult than it is now to enforce it, since the other side would also, let's assume that there was a scenario of Italian torpedo, and then the court decides to keep it. There is no other side to counteract that in the Court of Justice of the European Union. And then on the other side, I would understand that your thesis would be, well, in that case, the agreement will be protected by a anti-suit injunction. But in that case, what I can see is that the European Union may shield itself against any enforcement anyway of that injunction, which wouldn't exist now. And additionally, it would be a question of the Italian court, or whichever other court has decided to take that case inappropriately, may decide to just go ahead and never recognize any decision in another way.
They might, and it wouldn't matter a bit. Because although there are cases, they are exceptional, where people attempt to directly enforce anti-suit injunctions. I actually mentioned a rather unusual pair of cases a moment ago where that was done in the French courts, where the anti-suit injunctions supported an English jurisdiction agreement. But the reality is that is not how they're enforced. They're enforced by means of contempt proceedings against the party in the foreign proceedings. The whole grant of the anti-suit injunction is predicated on the fact that the respondent, the person at whom it is directed, is subject to the jurisdiction of the English court for that purpose. So actually, I mean, it's always been the case that anti-suit injunctions are enforced largely indirectly by means of contempt proceedings, not directly by means of any step you might take in the foreign court. It wouldn't matter if the Italian court proceeded. It would just expose the claimant in the foreign proceedings in Italy to the English court's contempt power.
I'm going to say something later on about anti-suit injunctions when my turn comes to be the speaker. Who wants a hand up the back? Yes.
I was going to suggest perhaps a bit of a modification of your statute option, because if we came out, then I think it might be very useful to immediately ratify the 2005 Hague Convention, so that as far as jurisdiction agreements are concerned, we get the reciprocal arrangement with the whole of the European Union, because they have ratified 2005 Hague Convention. But we also have our statute, belt and braces, making it national law and extending the application of the convention to any jurisdiction agreement. But because obviously at the moment we've got only a very limited number of countries which have ratified Hague. And personally, I like a further extension for maritime contracts, because the Hague Convention doesn't apply to them. which is disastrous.
All I can say is I'm very willing to accept that amendment. I think it makes a lot of sense. So essentially what we're saying, Yvonne, is that we would simply take care of the fact that the Hague Convention does not have very much international reach by simply making the same provisions in the context of my hypothetical statute. Yes. Yes.
And that, of course, would mean that our courts would recognise choice of court agreements in favour of non-Hague countries.
Mm-hmm.
It wouldn't in itself mean that they would recognise choice of
No, indeed, but that's where we are now anyway. I mean, that's so, yeah.
Who else wants it? Yes. That lady first and then gentleman afterwards.
Thank you. Thinking to the Gambazzi case and up to the Court of Justice, this case doesn't deal with the prorogation agreement, I remember, but was a case of contempt of court by the defendant. In that case, the public order of the member state was not allowed according to the Brussels regime. But without the Brussels regime, public order of each member state would allow to refuse the recognition and enforcement of decision given by English courts. In this case, do you think that can happen on one hand? On the other hand, I would like to go back to the Gassel case that already has been reminded by the speaker before me. Today, in this case, was really a case of choice of court or prorogation agreement in which the wrong jurisdiction has been previously seized. And really, that doesn't affect in any way the decision by English court. Do you think that they will follow proceeding the case and they will end up to different decisions?
Well, I think there are two things there. I mean, yes, you're absolutely right about the enforcement of contempt orders, but I mean that is itself a very unusual thing to attempt to do. I mean, again, I go back to how anti-suit injunctions characteristically work. I mean, as it were, the enforcement is domestic, if I can put it that way. I don't think that's an issue in any way. I mean, I think the issue about the effect of preemptive proceedings in another member state. Well, of course, in the brave new world post Brexit, where we're all trying to figure out what to do, I mean, the existence of pending proceedings in the Italian courts wouldn't, in principle, make a difference. It would make a difference. I mean, if we had Lugano in place, or Brussels, it would make a difference because we're back to Gaza. It wouldn't make a difference if we'd actually moved away into a world where we were actually doing our own thing entirely unilaterally, because the English court would simply take no notice of the fact that the proceedings had started elsewhere. But I think my point is that the difficulty caused by torpedo actions, which would be a difficulty under Lugano, would be ameliorated if well, not in the case where we were bound by Lugano, because obviously the ECJ's prohibition on anti-suit injunctions would still operate in that situation. But apart from that, it wouldn't be a problem. But I mean, let me say that is, in some ways, an argument. I mean, I'm not saying it's all about anti-suit injunctions, but it is at least a small argument for not going down the Lugano route.
I do apologize, but the problem that I see is that according to Gambazzi case, a lot of institutions of the English procedural law will be scrutinized by the actual European member states as a branch of the Article 6 of the European Convention of Human Rights.
Oh, I see what you mean. Yes. Yes.
Yes, that's the...
No, well, okay, well, I mean, I can't, no, indeed, I mean, I can't deny that, though that, I think, is, yes, I mean, that is clearly the case, yes.
Can I add something on this? Because
okay, he wants to say something, and then that him will be up.
I was actually involved in a peripheral way in the Gambazzi case. Of course, what happened in Gambazzi was not what Richard mentioned, I'm sure, not intending to suggest is what happened. What happened in the Gambazzi case is that Mr. Gambazzi failed to comply with the disclosure or discovery order under what was then a Moreira injunction, and as a result of that had procedural sanctions imposed on him, namely his defence was struck out. So what was actually being enforced in Italy was a default judgment, because it had been entered in default of appearance. Now, the question of whether or not being denied the opportunity to defend himself offended Italian public policy was an issue that was then judged against the fundamental tenets of public policy in the Cromwell case and others, and said that that's largely to be equated with the European Convention on Human Rights, which means that you wouldn't have carte blanche to apply old-fashioned national conceptions of public policy because of the constraining influence not of EU law, but of the Strasbourg Convention.
Yes, yes, well, I take that point. Yes.
But of course, the Italian law would still have a role to play within limits laid down by the CJEU and the Human Rights Convention.
The CJEU did not decide the point. They said it's a matter for the Italian court to determine the scope of Italian public policy.
But I think they did put some sort of limits on. I mean, they said, you know, they must consider blah 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 whether what rights he had.
Right, but the limit of the European Convention of Human Rights is binding for each European member states. If you want the limit of the European Convention of Human Rights, you can take care of the Charter of Fundamental Rights. It's mandatory for each member state now, and will be mandatory even if you Brexit.
I think that gentleman.
Yes. Just a question for Richard, and coming back to the domestic context again, and this, and obviously in the scenario that we're all talking about this afternoon, this unilateral legislation that you posited, first of all, who do you think would draw it up? Would it be something like the Law Commission? And secondly, where do you think that it would be somewhere in the government's top 200 priorities in that?
If we leave the European Union.
Well, I'm sure the answer to your last point is no, but then I don't think jurisdiction agreements generally, I don't think many of the issues we're discussing today would be in the top 100 priorities actually on that point. Perhaps I can just add one thing though. It's not really an answer to your question, but it might explain where I'm coming from. I don't know how widely known this is, but I think I'm giving nothing away. At the time when the UK decided not to opt into Rome I, it seemed to a lot of people that we would eventually opt into Rome I, which of course is what happened. But certainly there were those in government, I mean, that's to say those in the Treasury actually, not in the Ministry of Justice, who thought that the best solution would be to have a domestic statute, not to go into Rome I, but on the basis that the Rome Convention would no longer apply, and if it did, we'd just denounce it. There was work done on whether we would simply have a domestic unilateral statute. So I think, I'm not saying the Treasury would do this, but they were certainly working on that as a possible alternative to opting into Rome I. I mean, I would suggest, actually, that the City of London law firms might like to convene a working group which might produce such a thing, at least as a model law.
I think we have a question over there. Okay, and then after that we'll stop for tea. So our last question.
Yeah, just I have a question for Richard. Yeah, you have mentioned it at the beginning about the arbitration. I mean, I'm from a country that doesn't recognize choice of court agreement. I mean, the position to encourage Kuwait to recognize choice of court agreement. But the other argument that we have arbitration by New York Convention, and arbitration provides maybe the same advantage which you mentioned, legacy, predictability, reduced risk in litigation, reduced risk in conflict of judgment. This also can be by arbitration. But do you think that choice of court agreement can provide something that arbitration cannot?
Well, that's a big question. And the answer is yes. I mean, historically, of course, certainly in large financial transactions, one would never even have dreamt of arbitrating, simply because of all the procedural advantages associated with litigation, the quick enforcement, the fact that you can join third parties and so on. What has happened is actually post-GASA is that there's been a move towards not so much having arbitration as an alternative to court jurisdiction, in the sense of not having a jurisdiction clause, but inserting optional arbitration clauses in large dispute resolution clauses. But I think that's only as a way of getting around that problem. I mean, Karen can probably answer this better than I, but I mean, I think there is still a resistance on the part of commercial parties, I mean, certainly to large financial transactions, to having their disputes arbitrated.
So thank you so much, Burkhard. I have to address the question of the respondents' parallel proceedings rather lease pendants, because I won't have the time to address related actions, so I will concentrate on the question of lease pendants. And we talked, Trevor and myself, before in trying to decide more or less not to overlap. And he will address the perspective of the UK, and I will address the perspective of a member state. With this, addressing these topics, this would be the outline. In a scenario where my idea is that neither the Brussels Convention nor the Lugano Convention will revive, let's say. So member states are left with the Brussels I Recast in order to deal with the case of parallel proceedings. I will talk about what will not happen. Then I will try to address what will happen, and then I will conclude. So what will not happen is something that already Richard has talked about this. The recast, the articles related to lease pendants and related actions of the recast will not apply. That means that the UK court will not profit from the rule of the prior in tempore of Article 29. What might be more important is that Article 31.2 will not apply, so the choice of court exception to the lease, exception to the lease pendants rule will not work in favor of the UK court. And what I would like to stress is that I said at the beginning I don't think that the Brussels Convention will revive, but still if it did, some rules which are now in the recast will nevertheless not apply because they were not in the Brussels Convention. So Article 21.2 would be one of those provisions, and the provision related to how we determine the court first ceased, so Article 32 will not apply either under the Brussels Convention. What will happen? Well, suspense, because as has been already said here several times, we really don't know what will happen, even from the perspective of the member states who have provisions in the recast. The first thing that has to be solved is whether actually the recast covers all situations of lease pendants concerning third states or not. It could be that the residual rules on lease pendants, the national rules on lease pendants, are also applicable in case of a Brexit. While if you go to Article 33 of the recast, it starts with a sentence saying the member state which has been seized in the second place should have jurisdiction based on Article 4 or on Article 7 or 8 or 9. What does this mean? From my point of view, it means that if, of course, it's not said in the article, but it means that if a member state has jurisdiction which is exclusive, so Articles 24 to 26, or jurisdiction based on the sections protecting weaker parties, in this case, the lease pendants rule will not apply. But it also means, this condition on jurisdiction based on Articles 4, 7, 8, or 9, it also means that in case the defendant is domiciled in a third state, like for instance the UK, the recast will not apply, but the national rules will. Why do I say this? Because all rules, Article 4, 7, 8, or 9, are applicable under the condition that the defendant is domiciled in a member state. So this means that they wouldn't in case the defendant is domiciled in a third state. Therefore, I think that there is still a place for the residual rules on lease pendants to apply. I will then address first the scenario where the Brussels I Recast would solve the situation, and then I will address very briefly the situation of the idea is that we don't really know what is going to happen because these rules are, or Article 33, are very difficult to understand. Starting from how to interpret this rule, I don't think, Richard said before that you expect the ECJ to try to clarify how these rules apply. My impression is these rules are so open-ended, they give so much discretion to the member states that finally it would be a kind of oxymoron that the ECJ tries to fix how to apply them. So of course we can address questions to the ECJ, but probably the answer would be similar to this, to the answer concerning public policy. well, you are more or less free to act because the article is as it is, let's say, the provision. So we have two choices regarding interpretation. We could go for a uniform interpretation or for a national interpretation. And well, it wouldn't be so surprising that we interpret this rule like the national rules on lease pendants, because finally this would be consistent with the national residual rules on lease pendants for the different member states. And if you read Article 33, there are conditions which with member states like France or Germany or Austria are already familiar with. So it would make sense for them to simply try to apply Article 33 in the same way they are already applying their own national rules. So this would speak in favor of a national interpretation of this article. We could, of course, go for a uniform interpretation, which would be an interpretation looking at the objectives and the principles underlying the regulation. But then the problem is, which are the principles or the objectives that we are pursuing with Article 33? I don't think that the underlying principle is comity. It could be the intention to avoid parallel proceedings. This would mean that Article 33 should be interpreted in the light or together with Article 29. It could be, instead of thinking about parallel proceedings, we could think about the intention to avoid incompatible judgments, but then Article 33 would have to be applied in the light of Article 45. And there are differences. And well, finally, you could think that Article 33 has been conceived for a proper administration of justice, and then we are completely lost. So this would be my first question, what should be the interpretation, the criteria for interpretation to be followed. Now, if Article 33 has 4 paragraphs. The first one is the one allowing the states to, because it's a possibility, the court of the member state ceased to state the proceedings, provided several conditions are met. Second paragraph is the member state court could resume the proceedings, and it's also a may, it's also a possibility. The third paragraph is compulsory. In case the proceedings in the third member state had concluded, then we have to stop the proceedings at the member state. And then the fourth paragraph is an operative rule. So if we simply read these different paragraphs, I cannot help being puzzled, because all that I find are rather open questions. So what's the meaning of timing when the court of the member state is seized? Are we supposed to interpret this rule in the light of Article 32? According to the wording of Article 32, it could be possible, because the wording relates to the whole section. But on the other hand, 32 is meant to be applied in a system which is coordinated, and obviously if the UK becomes a third state, we will not be coordinated any longer with the UK courts. And also from the systematic point of view, Article 32 comes before Article 33, so one could say that it's not applicable to Article 33. On the other hand, and here is where interpretation in the light of Article 29 or 45 makes sense. If you read Article 45, it is meant to give priority to the judgment who has been rendered prior in time, not to the judgment who has been rendered following a claim which was prior in time. So what matters is the date of the judgment, not the day of the claim. So I really wonder whether even this condition of timing, the member state being seized in the second place, is relevant or not. And it depends, as I said, on whether you read it in the light of Article 29 or in the light of Article 45. I also wonder whether it makes any sense at the end of the day to only to have this temporal condition without having a look at what the other country, in this case the UK, thinks about it. So, well, as I said, it's a mystery to me. Well, same cause of action, same parties. We would be facing, applying Article 33, we will be facing the same difficulties that we already have under the Article 29. it is expected that the court of the member of the third state reaches a judgment, delivers a judgment. What it is expected means which burden of proof at the moment when we have to decide on whether to stop the proceeding, to stay the proceedings or not. The judgment will be, should be capable of recognition, and here we are including two factors of uncertainty. The first one is recognition will be assessed by each member state in the light of the national system, because the recast will not apply any longer to the recognition of UK decisions. And what is the meaning of capable? Which are the elements which are going to be assessed at that point of time in order to decide the stay? And will these elements be the same in Spain and in Italy, for instance? So again, uncertainty and fragmentation. Or the judgment should be capable of enforcement. Does enforcement here mean exequatur, as it was the usual meaning of enforcement, quite a technical in the formal regulations? Or enforcement means proper enforcement as it does now in the recast? And then the assessment would be really, really difficult at this point, because, well, exequatur is maybe something not so difficult to assess, but proper enforcement is really difficult. Well, and finally, the proper administration of justice. Of course, there is this recital 24, which tries to clarify a little bit what the proper administration of justice could mean. But first of all, it's a recital, so it has no binding force. Second, it's non-exhaustive. It doesn't pretend to be exhaustive. It's only finally, it's only a guide. It only addresses procedural conditions for the proper administration of justice, so one can wonder whether substantive conditions could also be taken into account, such as, for instance, which is the probable decision on the merits that will be taken in the future by the UK courts. In academia, the debate is, of course, open. You have people like, or authors, like Pippa Rogerson, who says, well, this is a kind of non-convenience, so it would be very difficult to apply from the point of view of the member states, continental member states, but easy to understand from the point of view of the UK. And, of course, you have the authors who react and say, well, no way. For non-convenience has always been an unfamiliar notion in this Brussels system. It has been directly rejected in the Brussels system. So what we have to build up is a notion of proper administration of justice, which is properly European and which meets the regulation. And I wonder whether this means to try to find the meaning of proper administration of justice in the European Court of Human Rights case law. And I don't think so. First, because of the margin of discretion which is given to the states, to the contracting parties. And second, because even within Article 6 of the European Convention of Human Rights, you have very different approaches to what the proper administration of justice could mean. It could be a subjective meaning, so the right to a fair trial, but it could also be institutional meaning, so that courts have to work properly, the load should be appropriate, or let's say specialized courts are better than non-specialized courts. So this would be for the stay. If we move to the resuming of the proceedings, we again find more or less the same problems. The wording of Article 33 is not clear for the member states here. Professor Schlosser, when commenting on this article, I think he simply says, well, I don't know what discontinued means. A stay is for something more familiar. Discontinued, I have tried to find a definition, and it means, apparently from the effects, there is no difference between a stay and discontinuing, but from the point of view of the causes, what causes discontinuity of the proceedings and what is the cause of a stay, this could be different depending on the procedural regimes. Okay, could be. Then the member state court could resume the proceedings if it is unlikely that the UK court would finish in a reasonable time. What is a reasonable time? And again, it has to be advised for the proper administration of justice. The only thing that we know about the proper administration of justice in this constellation is that it's not the same proper administration of justice that in the case of a stay, at least in a specific case, because at the first stage it meant a stay in the proceedings, and now it means resuming the proceedings. So circumstances have to change a lot before the third court, the third state court, and the proper administration of justice has to mean something different. Now, if we go to the dismissal is compulsory, okay, so this is, but again, open questions. Dismissal, does it operate under the same requirements as paragraph 1, meaning in particular that the UK court has been seized in the first place? And this is something that could be discussed. Why? If the objective of the provision is to avoid parallel judgment or incompatible judgments, we don't have to look at which claim was initiated first. We simply have to see what we have a judgment. Let's stop it. Doesn't matter whether the UK was seized second or first. Proceedings concluded could mean without appeal, with appeal. So again, we are in a situation of uncertainty that will depend on the national, probably the national systems, because at the end of the third condition is that the judgment is capable of recognition or enforcement, and most of the times national residual regimes of recognition or enforcement have a rule on whether the foreign judgment has to be final or not. So probably the second condition will be embedded in the third, but well, this will depend on the national system at stake. And finally, the rule may apply ex officio or upon request of one party, and this is set by Article 33, so the member states are given freedom in this respect. And well, for some authors, it should work ex officio because this is how Article 29 in the regulation recast works, or it should work upon request if this is the way it works under the national systems. And in this regard, it was very funny. I found one example of how lis pendens in Italy works, and it used to work ex officio until 2012, and since then, because of a decision of the Court of Cassation, it works upon request. So what this means is that there's, again, no uncertainty because systems are fluent, they change, they even change without the intervention of the lawmaker, so it's going to be quite difficult for the parties to assess what is going to happen under these provisions. Now, I will finish quickly, as if I hadn't talked quickly so far. A variety of solutions. In the case we move to the national scenarios, or the national rules of on lis pendens, there are 3 different scenarios. No lis pendens exception for cross-border cases. This was, for instance, the case of Spain until last year. Lis pendens exception was simply rejected because in the mind of the courts, the Spanish courts, how could you read the crystal ball and decide what is going to happen with the proceeding pending before the other court? So no lis pendens at all. Codified rules, like in Italy or in Spain since last year, there was a completely change of mind in the Spanish panorama. Or you could have no codified rule, but practice, quite a lot of practice, like is the case of France, has been for a long time. So the situation will be, again, one of fragmentation. And of course, the conditions to apply the lis pendens exception, in case it exists, will be different, or at least different interpreted in the different member states. So what is my conclusion? When I was to conclude, I felt so puzzled that I thought I could not get to a conclusion, and that's why my conclusions disappeared. And finally, I decided that I didn't want to conclude from the point of view of the member states, but rather from the point of view of the UK position should they leave the European Union. And I am not quoting in French on purpose. The quote is in French, so that's why. Well, there are big chances that the Article 33 is applied in a very different ways. The French love this idea of geometry variable. And of course, not being a member state is going to be expensive. Thank you.
Thank you. I'm going to assume that we leave the European Union and that there's nothing that takes the place of the current regulations. I mean, that's, in other words, that there's no Brussels Convention continuing, there's no Lugano, and there's no Hague. I'll just assume that. Now, I know that's hypothetical, but then the whole thing is hypothetical. So I think just to make it a bit easier, to limit the endless possibilities, I'm going to assume we leave the European Union and there's nothing in its place. And then what will the English court do in the case of parallel proceedings? And the answer is very clear and known to almost all of you that there is no lis pendens rule in England. England does not apply the lis pendens doctrine. So the fact there's another court in Italy or Sweden or somewhere does not prevent the English court from hearing the case. It doesn't matter who was seized first. We don't really care much about that. What would happen in England is that the English defendant, the defendant in the English court, will probably ask the English court to stay the proceedings on the famous doctrine of forum non-conveniens. And the English court would then consider, it will consider which court is more appropriate, the English court or the foreign court. And as I say, it doesn't really care much which was seized first. It would look at all relevant circumstances and decide which is the more appropriate court. If it decides the foreign court's more appropriate, the English court will stay its proceedings. And assuming the foreign court is willing to hear the case and does hear the case, that will then be the end of the matter as far as England is concerned. And then the foreign judgment will probably be recognised in England. Assuming the English court does not grant a stay, then the issue of anti-suit injunction arises. And it's important to realise that the mere fact that the English court does not grant a stay does not automatically mean that an anti-suit injunction will be granted. It's a separate issue, and there have been cases in which the English court has refused to grant a stay and refused to grant an anti-suit injunction. So okay, let the two cases proceed, and they have proceeded. However, the English courts do quite often grant anti-suit injunctions, and particularly if there's an English choice of court agreement or arbitration agreement. But I'm not going to talk about arbitration because that again leads us in all kinds of directions. And because time is short, I want to just limit myself, having said what I've said already, to a couple of issues. And I think we all agree that putting arbitration on one side, choice of court agreements are the most important source of jurisdiction of the English courts. And so I want to consider what happens if there's an English choice of court agreement and parallel proceedings in another country, Germany, let's say, or Italy, or whatever country you want to choose. What happens? And I want to make simply 2 points. The first point is this. Assuming the other action is brought, let's say, in Germany, and assuming the German court has jurisdiction under the Brussels regulation, because the defendant is domiciled in Germany. I mean, let's assume there's a German defendant and a French claimant, and they sign a choice of court agreement designating the courts of England, and then the Frenchman sues the German, or the French company sues the German company in Germany. The question is, first of all, we know that the rules, we're assuming Britain's left the EU, left the Brussels regulation. The Brussels regulation has provisions on choice of court agreements, but they only apply if the chosen court is in the European Union. So England won't be in the European Union anymore. And I'm also assuming all this takes place after we leave. I don't want to consider the choice of court agreements before we leave and the cases after we leave. Let's assume everything is after we leave. So in that case, those provisions will not apply. So my question is the German court where the action is brought either required or permitted by EU law to grant a stay in favour of the English court? And I think what Richard said, this is a contentious issue, so I'm going to be contentious. And we know, if you read the Schlosser report, and if you read the Korek case, which was mentioned by Professor Pfeiffer, both those cases, both the report and the case, say, well, the regulation does not require the court to stay, but they both say it's permitted to stay. The correct case said that the court will apply its national rules and may grant a stay. However, that conclusion, which is maybe quite favourable to the English point of view, because we hope the German court, if it's permitted to grant a stay, we hope would grant a stay, that conclusion is severely undermined by the Lugano case. Now, Lugano was a judgment by a Grand Chamber of the Court of Justice, and I think there were 21 judges sitting. The correct case was a mere ordinary chamber with 3 judges. So obviously if there's a conflict, Lugano, which was the later case, has got to prevail. And in the Lugano case, the Court of Justice was asked whether the new Lugano Convention, 2007, will be concluded by the European Union and the member states, or by the European Union alone. And it said the European Union has exclusive competence. The member states are not permitted to be parties to Lugano, and they're not. Now, how did the European Court reach that conclusion? Under EU law, exclusive competence exists if the new convention affects existing EU law. And the Court of Justice said it does affect the Brussels regulation. This was the Brussels 2000 regulation. How does it affect it? And it gave an example quite similar to my example. It gave an example of a choice of court agreement in favour of a non-EU Lugano state. Let's say Norway. It didn't specify, but a Lugano country which is not an EU country. So you have a choice of court agreement in favour of a Lugano state, Norway, is my assumption, and then you have proceedings against a defendant domiciled in the EU. He's sued in the member state in which he's domiciled. CJEU says, without Lugano, the EU member state must hear the case. With Lugano, it cannot hear the case. And that seems a clear statement that, in my example, if you have an English choice of court agreement, the UK has left the European Union, the German court will not be permitted to stay. Now, I know there is Mohammedia and Algeria, which Professor Pfeiffer mentioned, and he said, and I agree with him on this, that only affects labour employment cases and a few similar things. So this is the one situation. I don't think the picture is so rosy that we may find that EU courts are not allowed to stay in favour of a UK, even if there's a UK choice of court agreement. I think there is a case coming up from Romania, the Taser case, which will perhaps...
It has already been decided.
It's gone, but it said nothing.
Has already been decided.
It's already been decided and said nothing. Okay, so I can say nothing. Anyway, that is the one fly in the ointment, the one problem which could exist, that it may not be so rosy. The other problem concerns anti-suit injunctions. And I think a lot of English lawyers think that only if we could get rid of the European Union, we'd be free to use anti-suit injunctions, particularly if there's an English choice of court agreement, we could stop all that nonsense with an anti-suit injunction. And as Richard correctly said, we don't really care whether the foreign court recognises the anti-suit injunction or not. That hardly ever happens, and we don't expect it to happen. What we do is to enforce it directly against the defendant. So against the English defendant, the foreign plaintiff, by seizing his assets. In theory, we could even put him in prison, although that maybe won't happen. Still, we can do a lot of horrible things to him. And therefore, he will obey it. And that sounds great. And it does work very well, assuming, of course, the other side don't do the same thing. They don't throw an injunction at us. And we're quite happy that won't happen, because the Europeans don't do that sort of thing. The only country which does that is the United States. And when that happens, you can get an anti-suit war. And that did happen in the Laker Airways case. We sent through anti-suit injunctions at the American court, the DC Federal District Court of the District of Columbia, and they threw counter anti-suit injunctions at us. A counter anti-suit injunction is an injunction precluding someone from going to the foreign court, obtaining an injunction to start proceedings in your court. And who won in the end? The Americans won. The UK backed down, the House of Lords backed down and said, we rescind all those injunctions, the Americans can hear the case. Well, I don't think it's very likely the European Union will do that. But what the European Union could do, if they wanted to do, and if there's a divorce and they want to get really nasty, they could simply pass a regulation prohibiting anti-suit injunctions directed against EU courts. I mean, at the moment that's unlawful under EU law. Obviously, if we leave, that'll then change that. But you could have a regulation simply saying it shall be unlawful for anybody, anywhere in the world, to have an anti-suit injunction directed against proceedings in a European Union court. And you could also allow some public official to obtain a counter anti-suit injunction with all the same penalties, a daily penalty of 100,000 euros going up to millions, billions, whatever. It'd be quite easy to draft an effective anti-counter-suit regulation which would then terrify anybody with assets anywhere in the European Union from ever obtaining anti-suit injunction. Because I think an order of that kind would be enforceable under the Brussels regime, even if it's the state which is a government official which is enforcing it. And even if the money goes to the state, provided the original proceedings are covered by Brussels. And my authority for that is the Real Kemi Nederland case, in which the European Court said that an injunction enforceable by the German state is nevertheless covered by the Brussels regulation. The penalty, the money goes to the state, is nevertheless covered by the Brussels regulation if it's intended to enforce an interim measure, which is covered by the regulation, and interim measure would be covered if it's in support of a substantive proceedings. You can look at the case and see it. I said I'd be short, and I'm going to stop right there. I'm just trying to say that I think the garden is not so rosy if we leave, assuming, of course, we don't have some fallback position, but that's all depends. So thank you.
Yeah, what's yours?
In the example which you gave, Professor Harvey, of the English jurisdiction agreement, but the German court having jurisdiction because the defendant is domiciled in Germany. Yes. Under the recast, now, presumably the German court would have to apply Article 33, and if the English court were first seized, they'd apply the conditions and they might decide to stay in favour of England. But if we were not first seized, then
under the present regime, if you have a choice of court agreement, exclusive choice of court agreement, then the English.
No, but we're not under the present regime because we're out.
Ah, I see. Okay. So I thought you meant under the
no, we're
Brussels
out.
2000.
Your
right.
hypothesis.
Yes.
We're out.
Okay. My hypothesis is that we're out, and then what I'm saying is that at best the German court will have a discretion.
Yes.
But if you accept the Lugano case, then they won't have a discretion. They won't be allowed to stay. They'll have to hear the case.
But wouldn't they still have a discretion because of Article 33 of the recast? Because we'd be a third state.
Right. Yes. Okay. Yes. Provided the English court is seized first.
Yes.
Yes.
Yeah.
Then they would have a discretion under that provision, and that provision is not dependent on the third state being an EU state. So what Marta said, all her various points would arise in that case. That is true, yes. That is perfectly true.
Reaction from your side?
No, I just wanted to...
Maybe one...
Yeah, please.
Yeah, maybe one remark in addition to that. If there was a case with the choice of court agreement London, then certainly a German court, if the German court would not stay the proceedings, for which there was probably no basis in the Brexit situation, would have simply to decline its jurisdiction. Because under German autonomous law, if there is a clause, exclusive jurisdiction of London, German courts do not have jurisdiction. However, the real risk is that the view of the German court, whether the clause is really valid, and whether it confers exclusive jurisdiction, and whether everything is fine with the contract, could be seen differently in courts of several member states. I think that is the real risk. Most member states have autonomous laws and say, well, choice of court agreements are fine, we recognize them, and we enforce them. However, the problem always is the different view, and you see that, for instance, in all these cases where anti-suit injunctions play a role, as far as they are contractual cases. For instance, West Tankers. In West Tankers, the issue was, are all parties, or were all parties bound by the arbitration agreements? Because they did not directly sign it, but were the successors of some of the original parties. And these are the cases where the problems arise, I think. I mean, I'm not in the position to give any advice to the British. However, when you look at that, the issue is, would you like to have a guarantee that the same view is applied in Syracuse like it is applied as in London? Or would you prefer to be free and everybody does what they want? I mean, these are the options.
Alex Lane.
Can I just add one anecdote to what you're saying here? Because there's often a mismatch between the law and reality. I was informed, she should probably remain anonymous, by the president of a Oberlandesgericht in one of the commercial jurisdictions in Germany, that they frequently stayed proceedings under exclusive choice of court agreements in favour of third states, and nobody had ever argued before them that Article 2 was mandatory in its effect. This was before Owusu, admittedly, and before the before the Lugano opinion, or at least before it was so well understood. But she said, you know, in 30 years, she'd never heard an argument based on the Brussels Convention, Brussels Regulation, to the effect that the exclusive choice of court agreements in favour of third states were not effective. So it doesn't quite matter what the law says, it's a question also what the practice in legal professions is of arguing these points.
Richard.
Well, I simply wanted to first of all congratulate Alex as being the first person to mention Owusu and Jackson this afternoon, which of course is customary on these occasions. But the second, more substantive point, I mean, I can see that, I'm very pleased about this, that we're actually beginning to draft the new English statute here. Because obviously, it follows from what Professor Pfeiffer has said, that what we need to ensure is that the conditions for the effectiveness and validity of an English jurisdiction agreement in the brave new world track exactly those of Article 25 to ensure that there is no suggestion that we don't have a valid jurisdiction agreement.
Your question.
Marta, would you say that in relation to these clauses that you were looking at, these defendants of third countries, would that be a concession by the European Union to the forum non-convenience, but not necessarily well drafted and well adapted, since you open so many questions you open there to say in reality this lacked clarity? Would that be something of a concession, or is this actually something that it was trying to thinking of third jurisdictions?
I don't know if I follow your question, but if I understand it correctly, so you ask whether it would be possible to understand Article 33 as the forum non-convenience.
As a concession to to England, in a way, to the forum non-convenience under English law, or whether it's actually thinking of realistically a case like Jamaica and Owusu, for example. Are they actually thinking of?
I don't really know, because it would be like trying to read in the mind of the lawmaker. I was so I don't know whether really this article could be or was meant to be interpreted as a forum non-convenience clause. What I would like to point out is that even if it was, well, no, what I wanted to ask was something different from forum non-convenience, so I don't know whether, and I really don't know. I think we have to wait and see how it is used. But I would be surprised, because we are talking about member states, continental member states, applying something and doing it in the way you mentioned, so as a forum non-convenience would be probably a surprise for them. They are much too much in reading the rules and much less in this kind of discretion. But could I ask something on formal convenience?
Yeah.
Yeah. This idea that from the UK point of view, parallel proceedings could be solved because of formal convenience seems to me a little bit unfair to the litigants, because when I compare what I know from the formal convenience in the United States and in the UK, what I have seen is that usually in the formal convenience doctrine in the United States, what happens is that once the stay is accorded, or it is accorded because the defendant, so the defendant who is applying for the formal convenience, he commits to submit to the jurisdiction which is more convenient. So from the point of view of the claimant, who suddenly is left without the forum, from the point of view of the claimant, okay, he has to go to another jurisdiction, but at least he has the commitment of the defendant that he will appear, or not appear, but at least if he does, he will submit by appearance. Whereas I think that in the UK, but I might be wrong, this does not exist. So this means that formal convenience might be a way of the court to get rid of a case, but from the point of view of the parties, and mainly the claimant, is really...
I don't think that's right. I think in English court, it wouldn't grant a stay unless it knew the other court would hear the case, either because it's already seized of the case, or because the defendant agrees to submit, or because it would have jurisdiction. And if by some reason the foreign court did not hear the case, then the claimant could come back to England and ask the English court to lift a stay. There's only one case I've ever come across in my life in a common law country. I mean, obviously I haven't come across everyone, in which the court granted a stay when the foreign court probably would not hear the case. And that was a case, I'm not sure how you pronounce it, Pahlavi against Islamic Republic of Iran. Pahlavi was the family of the Shah. And that was a highly politicized case in which Iran was trying to sue the ex-Shah's family to get back the vast sums of money he embezzled. And the New York court didn't want to hear the case for political reasons, but it said if the Iranian courts grant a judgment, we won't recognize it, because the Iranian courts, in our opinion, are not fair. I mean, that was a totally unusual case. But every other case that I've ever heard of, there has been the alternative forum.
Yeah. I'm now in a very uncomfortable situation because we are a little bit running out of time. If you open up formal convenience,
I think we should close down.
Natural consequence, let's put it that way. Before we close, I would like to make one very short remark. I find it puzzling to see that if we don't have clear rules concerning pendency, etc., and we go to additional, let's say, battlefields like anti-suit injunction, damages for breach of choice of court agreements, etc., I'm not sure whether the parties finally will be better off if both sides are starting to just put it, these operations, let's put it that way, and finally we can end up in an enforcement carousel where judgments are enforced somewhere and will be litigated in another forum. And we should be aware that unilateral solutions sometimes entail adverse consequences for the parties, and litigation is about parties.
The question we're asking is what will a post-Brexit landscape look like? And I think the one message that we've all received today is that nobody knows. I don't know if any of you are, like my daughter is, fans of dystopian films, but I have a kind of dystopian vision of what such a landscape would look like, which I wanted to share with you. And there's a version of Westminster in a diminished and dysfunctional state as a result of Brexit. And that's probably the one thing we do know. Richard said earlier it's never happened before. I mean, he's obviously overlooked the detail of Greenland leaving the European community in about 1973, but I don't think there were an awful lot of parallel jurisdiction issues that arose on the occasion of Brexit, the earlier, first Brexit first, not Brexit the second, which also got raised. So what we're going to do today is we're going to discuss these topics. I'm going to make a brief introduction, then Tanya is going to deal with the meaty and difficult stuff, namely the repeal of the acquis, the status of the Lugano Convention, revival of the Brussels Convention, status of Lugano 88, and you will get the definitive answers from her because others have been tiptoeing around these subjects so far. And then I will look at the revival of the bilateral conventions, if we ever get that far, and then what would be left of English national law before she deals with national law of other member states. So we know, by way of just pointing out where we are, I thought pictures would help at this time of the afternoon. And you've had one. There's another one that's less dysfunctional. That is the territorial scope of Brussels I Recast as it stands at the moment. And it's a bright yellow, sunny existence. If you actually then include Lugano as well, so we've got 28 countries there, as we know, actually 30 jurisdictions. Please don't forget Scotland and Northern Ireland. So we have 30 jurisdictions there at the moment. If we go to Lugano as well, I painted Britain red as an appropriate colour at this point. We have 31 countries and 33 jurisdictions. So that's the scope of the systems in which we are presently a member, and if the British people are willing, we will still be members on the 24th of June. But if they're not, then we have to consider this afternoon's topics in more detail. Now, you will find, we've got another picture later on showing the territorial scope of the revival of the Brussels Convention and the territorial scope of the bilaterals, but this is for the purposes of comparison. We put those up first. We're going to move now to the repeal of the acquis. I'm just going to make one brief domestic law point before Tanya takes over, which is that Richard made the assumption that the European Communities Act would be repealed in total without more. Now, we're also talking about the possibility of a withdrawal agreement not being concluded within 2 years, and we all know what happens if we don't reach it within 2 years. There has to be an extension, but an extension can only be agreed by unanimity of all other 27 member states. So frankly, by that stage, it seems perhaps unlikely to have an extension. So the realistic possibility is that we don't get a withdrawal agreement. In that situation, any responsible government would try to avoid the sort of chaos that would ensue. We don't want all the regulations that deal with product liability, with the regulations as to the shape of cucumbers and the provisions as to cars, suddenly to cease to have effect. And I'm confident that the repeal of the European Communities Act would have within it a transitional provision that continues to give effect, if not to the whole of the acquis, certainly to substantial parts of it, until we were able to work out a more coherent future. 2 years is far too short a time to negotiate a replacement.
Yes, so we have seen already that what is going to ensue will be huge legal uncertainty. I will perhaps, as I have been asked, I will make 1 or 2 points about what Switzerland's experience is as far as I can judge upon that. Of course, I'm not a negotiator for Switzerland, but what I see I can perhaps communicate to you a little bit. What the UK might perhaps aspire to do is to get a parallel regime to the Brussels I regulation. Wouldn't be impossible to do such a thing, even perhaps within the scope of this treaty or the agreement on the UK's future relationship with the EU. So theoretically that would be possible, but I wouldn't really count on the EU's willingness to enter into such an arrangement. Because so far the EU has not been very keen at all to include non-members directly in the Brussels I regime. Switzerland has tried that, I think, several times, and it didn't work out. So it is actually much more likely that the future participation of the UK will take place in the framework of the Lugano Convention, if at all. Anyway, I think that regardless of the model that is chosen, be it the Brussels or the Lugano regime, the UK is going to lose a lot of its bargaining power. Because today I think that the UK's position as to bargaining power is very strong in the field of civil litigation because of the opt-in option. The Swiss experience is that as a non-member, you are perhaps allowed to sit at the table, perhaps even when new EU instruments are negotiated, but you don't get to say very much. You can listen to what the others are saying. There's another thing. The UK can now decide whether to opt into certain instruments or whether to keep out. And I wouldn't count on this possibility to remain, because I hear at least that the EU's approach is increasingly you can take it all or you can just leave it all. And this is increasingly, it seems, the EU's position also in the field of jurisdiction and judgments. That wasn't the case previously, but it seems to be increasingly the idea. So in future, the terms may be that if you want any cooperation at all, you just have to take it all, or nothing. So cherry picking, and I think that many from outside the UK have the impression that the UK gets to do a lot of cherry picking in the field of civil jurisdiction and judgments. This wouldn't perhaps no longer be possible. Well, of course you might hope that you will be in a different position than Switzerland is. You might hope that you're more important to the EU than the EU is to you, but I wouldn't count on that, because the EU is quite big nowadays and is an important player. So I think that the UK should not set its hopes too high as to the strength of its bargaining position. And I think that, I mean, we have heard if you're divorced, you perhaps retain a little bitterness, but there's also a rational idea behind it, because I don't think that the EU will want to risk creating the impression that it's a good thing to go out of the EU, because there are other economically strong states in the EU that might just then start feeling that it might be better for them to move out as well. And I think that the EU will do everything to prevent this idea. Therefore, I think that regardless of the model that you choose, may be difficult as to bargaining power. Well, as for the Lugano Convention 2007, I think it has been said correctly that it would be possible to exceed the Lugano Convention. I don't think that the UK would automatically be a member. I think there is no basis for this in public international law, not even if the Treaty on State Succession to international treaties were applicable. I think not even then the UK would automatically become a member, but you could accede. Well, the Lugano Convention has there are some drawbacks, especially from the UK perspective concerning jurisdiction agreements, and also the development always lags back somewhat. If you think 2007 it was signed, the Lugano Convention, and that then created a parallel situation to the Brussels regulation. 2011 it came into force, and 2015 the recast Brussels I came into force. So there was a parallel situation for 4 years after years and years of negotiations. And there's no regime yet in place to have some sort of automatic updates. So that's the drawback, but otherwise, of course, you might enter the Lugano Convention. As for the Brussels Convention of 1968, well, I think there are a lot of open issues. Some have been addressed. Whether the Brussels Convention is still in force at all, probably yes, in a way. So let's assume it was only suspended. I think also then a lot has been said about only an EU state being able to be a member of the Brussels Convention. I share the views that have been expressed in that respect. And I think that even if there is no automatic termination because of the UK no longer being an EU state, I think that at least leaving the EU might well be interpreted as a fundamental change of circumstances that would then permit the other members to withdraw, and probably the EU would be in the position to then withdraw from the Brussels Convention, even if we assume that it's not automatically terminated. And we have seen that it only applies to a fraction of today's EU member states. As far as I can see, I don't see that the new member states have acceded to the Brussels Convention. And it's meant to be replaced by the Lugano Convention anyhow, also for the overseas territories, as far as I understand. And, of course, it would mean returning to an outdated regime. So I don't really think, I mean, a lot has been said about this being an option. I don't think it's an option, really. As for the Lugano Convention 1988, that's even less an option. Well, one difference is the UK itself is a contracting party. That's a difference to the 2007 Lugano Convention. The UK is a contracting party, and membership is not limited to EU member states. But I think that the old Lugano Convention is not anymore in force because it has been replaced by the Lugano Convention of 2007, and I don't think that there's an issue with the EU's power to do that, because that is today the EU's exclusive competence to make agreements in that field, and I guess it's also their exclusive competence to abrogate agreements in that field, because all parties of the original Lugano Convention were represented in the 2007 Lugano Convention, and I think that this convention is just no longer in force. And obviously, a lot of the problems that I have mentioned with respect to the Brussels Convention also apply to the old Lugano Convention. So limited membership, only Poland of the new members has acceded. The EU itself is not a contracting party, so the convention does not apply in the member states that have not themselves joined. And of course, it is the Middle Ages of the development of the European judicial area. So this very briefly about these instruments, and Alex Layton will now talk about the bilateral conventions and English national law. Thanks.
The bilateral conventions, as Burkhard Hess said earlier, were completed with a number of member states. We'll look at them in a moment, but just have a look and see what the Brussels I Recast says about it. It says that, subject to some articles which need at the moment published, this regulation shall, as between the member states, supersede the conventions that cover the same matters, and in particular the conventions listed in a list which the Commission keeps and publishes are superseded. Now, that's almost exactly the same as the Brussels I version, except that instead of telling the Commission to keep the list, they set out the list in the Brussels I Recast. Now, use of the word superseded is significant. You would have seen that the word used in the Lugano Convention 2007 is that it they use the word replace the Lugano Convention for 1988. And the reason, of course, somebody picked up on it earlier, is that the Brussels Convention had a continued vestigial existence and purpose after the Brussels I regulation came into effect. I delivered a talk some years ago called "The Sun Never Sets on the Brussels Convention," and the reason was that there were places around the globe on which at any given day, if there were no clouds, the sun would be shining, where the Brussels Convention continued to apply, and they include Aruba and one or two other territories. It's been rather whittled down over the years, but that is still the case. But there are more important reasons why the Brussels Convention, why in the case of the bilateral conventions, they were not abrogated in their entirety by the Brussels Convention of 1968, and indeed the other pieces since. A number of reasons. Firstly, there were territories to which the old bilateral conventions applied that the Brussels Convention did not apply. For example, I noticed that the convention between France and the United Kingdom applied, from the United Kingdom's point of view, also in respect of New Zealand and Hong Kong, because those states, this is Article 70, that's just saying that the conventions continue to have effect in relation to matters to which the regulation doesn't apply, it doesn't add much. The list is kept by the Commission, and if you want to see the list, you need to look at the European Judicial Network's website. It is actually published somewhere in the depths of the official journal somewhere, but actually look at the website and you can look at it country by country to see where their bilateral conventions were. Now, these are the 6, or rather, there was one with Norway as well, which I've added on the list because of its Lugano status, but there were 6 with other member states. And some of these, of course, predate the independence of some British colonies, New Zealand, and indeed Hong Kong's reversal to China. And from the French point of view, they then were given effect in respect of Laos and Lebanon, for example, when they obtained their independence. So while they did not represent bilateral conventions between the United Kingdom and France any longer, in respect of the matters to which they applied, they had existence outside that. So they're not completely abrogated, they're not completely superseded. But there are other reasons why, even as between the United Kingdom and other member states, these bilateral conventions continue a shadowy existence. Their subject matter scope is the best reason, because the temporal application point is now somewhat spent after the Brussels Convention came into force in respect of this country jolly nearly 30 years ago. But the subject matter scope is a bit different. The subject matter scope is narrowly defined, or rather very generally defined in very few words, as being civil and commercial matters. But you can't assume that what they meant by civil and commercial matters in a 1934 bilateral convention is the same as the definition that finds itself in the Brussels I Recast. Let me give you an example, not from the bilateral conventions, but I think from the Hague Evidence Convention, which is said to apply to civil and commercial matters. Those phrases, that phrase was the subject of examination by the House of Lords in the State of Norway case on the Taking of Evidence Convention of the Hague Taking of Evidence Convention, and held specifically to have a different meaning from that which applied in the Brussels Convention. It's applied in that case to interim measures for the purpose of taking evidence in support of a taxation regime, which is strange given the public international law prohibition on the recognition of judgments in foreign tax matters, but the scope of the civil and commercial matters phrase plainly does not necessarily have the same meaning as in the Brussels Convention. So these may still have a vestigial existence enough to have fresh life breathed into them, and the effect of it will be that if the whole Brussels-Lugano regime ceases to have effect, these bilateral conventions may be useful for the purpose of enforcing judgments in other countries. We see a picture of them there. The blue countries are the ones with which we have bilateral conventions. In Norway we have one as well, although if Lugano doesn't continue to have effect, then the Norwegian bilateral convention will also be of relevance. Now, what do? They do much more limited things than the recognition regime under the Brussels-Lugano regime. They only apply to judgments of superior courts, for the most part. They only apply, as I say, in civil and commercial matters, and that doesn't necessarily mean the same thing. And they have this old traditional set of approaches, and the indirect rules of jurisdiction. That is to say, you're not bound by the Court of Origin's decision as to its jurisdiction. The Court of Origin can apply whatever jurisdictional rules it likes. What you're interested in when you're the state addressed is whether or not the judgment was given by a court that had jurisdiction under your conception of the rules of jurisdiction. And the common law position, I'm paraphrasing it somewhat, is presence or submission. There are actually a rather larger number of spelt out conditions in these bilateral conventions, but they amount basically to that. If you were a plaintiff in the original proceedings and the judgment is against you on a counterclaim, or if you are a company and you have your registered office there, and various spelt out things, but basically it amounts to presence and submission. So you test on every judgment that's been brought to you for enforcement whether the court of origin had jurisdiction. And there are other grounds on which recognition can be refused that will be more familiar in default judgments. The French Convention, for example, refers to actual notice, which is, has the merit of clarity to the defendant, insufficient time to enable him to arrange his defence. And then there's a broad spectrum, refusal on grounds of public policy, but interestingly that concept, again, is different from the Brussels concept, because it is specifically includes conflicting judgments, either with judgments from your own state or indeed with judgments given in third states which are entitled to recognition. Process fraud, if the judgment was obtained by fraud, and then there are concepts of immunity, state immunity is included. And interestingly enough, in the light of the considerations that played out at the time the Brussels Convention was adopted, the refusal on the ground, refusal is not permitted on grounds that the Court of Origin applied private international law rules or choice of law rules that differed from the ones that you would have applied. That, I think, was something of the favourite of the French, and the UK weren't going to have it in 1934, and nobody was going to have it after 1968. So I just want to say something about one other topic, which is not on our slides, which is don't forget the bilateral civil procedure conventions. Now, there were a whole lot of these, but rather more countries than the 6 that had bilateral recognition and enforcement conventions, and they date back further. They date back, in some cases, as early as 1922 with Belgium and France. They are almost entirely superseded by the Hague Conventions on Service of Proceedings and the Hague Convention on the Taking of Evidence of 1965 and 1970 respectively, to which a very large number of countries around the world are parties. But please note, all member states of the European Union are, give effect to both these conventions, except in the case of the Service Convention, Austria does not do so, and Croatia does not do so. So if you want to serve process in Austria or Croatia, you can't use the Hague Convention, but in the case of Austria, you can do it under a bilateral convention dating from 1931, and in Croatia, you can probably do it under a bilateral convention concluded with Yugoslavia in 1936. But there may be a question of state succession that arises in relation to that one. On the evidence convention, I'm afraid Austria again is in the doghouse. It has not given effect to the evidence convention either, but it has some other companions, as Belgium, which has also not done so, together with Bulgaria and our close neighbours Ireland. So if you want to serve, if you want to take evidence in any of those countries, you have to do it not under the Hague Evidence Convention. The Austrians and the Belgians, you can use the bilateral convention. Though with Bulgaria and Ireland, you'll be left to the use of your imagination or what other means that may be available to you to get the evidence in those countries. So that's how the bilateral conventions work. In respect of those countries where we do not have bilateral recognition and enforcement conventions, the bilateral enforcement conventions operate domestically under the Foreign Judgments Reciprocal Enforcement Act 1933, which puts into effect the terms I was referring to about the scope of the jurisdiction. Note in particular that they apply only to money judgments and not to non-money judgments. The common law is what you're left with, and somebody said earlier that it's going back to the Dark Ages. Have to start in Burkhard Hess. You go back to the Dark Ages if you have to start fresh proceedings on the enforcement of a judgment. Well, the Dark Ages are alive and well in London. It's the way you do it with a judgment from other antediluvian countries like the United States or anywhere else with which we don't have a bilateral or multilateral convention, and you have to start an action on the judgment. The good news is the snappy procedure. You can usually get a summary judgment on it pretty quickly. It's based on the doctrine of obligation, which is not that it gives effect to the judgment, but that the judgment itself creates an obligation which is the source of your cause of action, and it's pretty hard to find a defence to it because there are very few of them. So that's how that continues. Now, that will come back to life in respect of other member states with which we don't have bilateral conventions. Interestingly enough, under the 1933 Act, you've got to do it under the 1933 Act with the 6 countries with which we have them, or Norway, 7 countries. Unlike one of the other regimes, the Administration of Justice Act 1920, that applies to Australia and other places, where you can bring an action on the judgment as an alternative under the 1920 Act, but under the 1933 Act, you're not allowed to do that. And so you've got to do it by the registration process provided by the rules of court in respect of those 6 countries. Happy days. You'll see that scrappy old file there. That was a file I put on my shelf in 1987 and have not looked at since, which was all these bilateral conventions. I took it off there today and blew the dust off it.
Okay, so and what would this look like from the perspective of other member states? I'm certainly not going to bore you with that for a long time, but just a few short remarks. There's quite a bit of a variety of approaches to that issue in the other member states. So if actually none of the regimes is going to apply, there's going to be a lot of research to be done if you want to make sure that your judgment is going to be, or how your judgment is going to be recognized and enforced. Often, of course, it will be, probably will be if there was a jurisdiction agreement. Perhaps you cannot be even entirely sure about that, but even then. You must expect that there will be a review of jurisdiction on the basis of national law, which can be very different. In some states, the approach is rather liberal and only a sufficient connection to the state rendering the judgment is required. But in other states, let's look at Germany, for example, it is required that the foreign court had jurisdiction according to the rules of the national law of the receiving state, so the so-called mirror principle. What surprises people sometimes is that in Switzerland it is often, not in cases of agreements conferring jurisdiction, but very often, a judgment will not be recognized if the defendant was domiciled in Switzerland, even if Switzerland in the reciprocal situation would also have had jurisdiction from the Swiss point of view. So there are very many different and sometimes very surprising rules on the review of jurisdiction. Then there may be other requirements or grounds for refusal, for example, reciprocity. Luckily Austria has a bilateral convention with the UK. It's lucky because Austria doesn't recognize judgments from third states if there is no agreement on the recognition and enforcement of judgments. There may be other states also doing it like that. And often, of course, there are cumbersome procedures. Perhaps even a new claim is required. Sometimes the procedure is going to be very quick, even if a new claim has to be brought. Of course, the debtor often has the right to be heard already in the proceedings for recognition and enforcement, which is not the case under any of the Brussels or Lugano regimes. So the surprise effect is not guaranteed if you have to recognize and enforce according to national procedures. There may sometimes be workarounds with the help of provisional measures, but you cannot necessarily count on that. And it is difficult to obtain information. There is much legal uncertainty because many of these national regimes really haven't been developed further very much after the Brussels and Lugano regimes have been established because the relations to other EU member states are so important that somehow the development of the national regimes was neglected. Jurisdictional protection for UK defendants, you shouldn't forget that. What if a UK defendant is sued in another member state? If you're a third state, then the national rules on jurisdiction apply against such defendants, and judgments given on that basis have to be recognized and enforced in all EU member states without any scrutiny of jurisdiction. So you would be exposed to all the exorbitant bases of jurisdiction in the other member states, and the judgments would have to be recognized and enforced EU-wide. So I think not a very attractive perspective, so I think that joining the Lugano regime would probably really be a pressing need if Brexit were actually to happen. I don't think it would be a more attractive model than today's Brussels system, because you would be at the receiving end, also has already been mentioned, on the receiving end of ECJ judgments. You would be able to deliver opinions in the proceedings, but well, you wouldn't have a judge anymore. You wouldn't have the possibility to perhaps ask again if you weren't satisfied with the answer. You could have, of course, you wouldn't be formally bound to the judgments, but in Switzerland we see that even if there is no formal binding force, usually these they are sort of, well, de facto binding. Another option for the future perhaps might be the Hague Judgments project, of course, but we will see about that. I suppose it will take some time until that is the end is reached. There will be a special commission starting next week, but I guess it will take a few years until that is accomplished, and also it certainly won't be the same thing as the Brussels or Lugano regime. So I think, well, entering the Lugano Convention probably will be the only sensible thing to do after Brexit, but I think that being in the Brussels regime is more attractive. Thank you very much.
So Karen will start off. Thank you.
Thank you. Okay, given the time, I'll be quick. The purpose of this roundtable is to talk about the impact of Brexit on London as a dispute centre. When I think about this question, I think, first of all, about whether it will affect the approach that my clients take to including jurisdiction clauses in their commercial contracts. And I think some reasons why clients include jurisdiction clauses in their contracts will be entirely unaffected by Brexit, and Adam's going to touch on those points. But it's undeniable that there are some factors that may be affected, and the most obvious one, of course, is the one that Richard covered earlier when talking more generally about jurisdiction clauses, and that's enforcement. And I think it may be that some parties are put off from including English jurisdiction clauses because of the potential enforcement risk post-Brexit. If their counterparties have assets in a member state, you can't rely on the recast to ensure, assuming the recast doesn't continue or no equivalent regime continues, you can't rely on the recast to ensure enforcement of judgments. And that makes it much more difficult, I think, for clients to assess litigation risk at the time they're negotiating the transaction and to price that into their transaction. But having said that, I don't think you can necessarily push that point too far, and for reasons that have already come up this afternoon. First of all, where your jurisdiction clause is an exclusive jurisdiction clause, then assuming the UK signs up to the Hague Convention, then there should be enforcement under the Hague Convention. And secondly, where you don't have an exclusive clause, where you have an asymmetric or non-exclusive clause, then enforcement in many jurisdictions, I think, is at least in theory possible under national law, although I take all the points that have been made about the fact that that will be more difficult and more time-consuming. So would I give that new regime 8 out of 10 as Richard gives the recast? I don't think so. It's not as good as the current regime. I think the real question is whether those disadvantages are sufficient to outweigh the other advantages of choosing to litigate in the English courts. And there I think we'll see clients taking different views and continuing in many cases to include English jurisdiction clauses. Adam, I'll hand over to you.
Thank you. Yeah, next to say, in light of all the areas of potential uncertainty that we've identified, that the future of London as a centre for dispute resolution looks rather rosy in the case of a departure from the European Union. But looking at it more broadly, I think addressing this question invites you to consider why it is that people choose this jurisdiction as a centre for the resolution of their commercial and other problems. And I've identified 2 or 3 factors which, in my experience at any rate, are relevant, some of which have, or some of which are likely to be impacted by Brexit and some of which are not. The first, and I think probably the most significant to my mind, will not be affected. Because I think many people choose London as a centre for dispute resolution because they have confidence that we have a stable system of domestic laws, by which I mean substantive laws dealing with things like contract and tort, unaffected by interference or intervention by legislators from the European Union, and aligned to that a degree of confidence in the judiciary. If we think about the phenomenon of the growth of litigation in the London market involving former CIS states and Russian oligarchs, one of the reasons why London has become such an attractive centre for the resolution of large-scale disputes involving parties of that kind is that they have a degree of confidence in the quality and independence of our judiciary, and those factors will not change in the case of a Brexit. There are other factors at play, I think, imposing pressure on those characteristics of our legal system, but they're rather more to do with the funding and proper support of our judicial system and court system more generally, not really affected, I think, by the idea of a Brexit. So that's reason 1, stable legal system and high quality and reliable and independent judiciary. Those will remain, I think, very significant factors. Second reason that people choose this jurisdiction, I think, is that they assume that their choice, their contractual choices, and in particular their choice of jurisdiction, will be respected. And here I'm inclined, I think, to agree with comments that Professor Fentiman made earlier, that actually whatever the current system enshrined, reflected in the Brussels Recast is replaced with, it will be something as good as, if not better than that. So I'm tempted to think that this, again, is a relatively neutral factor, subject to one important qualification, which is that if we're left with a system which includes as part of its operation the functional equivalent of the old Italian torpedo, that may be a factor, and that may well put people off choosing London as a centre for dispute resolution. And there's some evidence for that, because when we had the Italian torpedo, in light of cases like Eric Gasser and other celebrated problematic cases, it was a factor, it did put people off. And Eric Gasser was followed by a very lively debate among practitioners about whether they should start advising their clients to move their business, as it were, from London and in favour of New York as an alternative commercial litigation centre, or in favour of arbitration. So reason number 2, choice will be respected, but I'm tempted to think on balance that's likely to be neutral. The third factor, which is more significant and more problematic, I think, is enforceability, because commercial parties will make a judgment at some point about the enforceability of the judgment that they are intending to pursue. And if, as Karen has pointed out, you're chasing potentially a defendant with assets elsewhere in the European Union, it may well put you off if compared to the fairly regular and predictable system we have at the moment, which more or less guarantees the portability of your judgment. You're presented instead with a patchwork, having to look at the individual domestic laws in 27 other states, or perhaps digging out Alex's dusty file. I mean, one qualification to that, which is that actually, in my experience, the question of whether enforceability is a significant factor insofar as it influences the decision about where to litigate is more of a factor, more significant at the stage when a dispute has arisen. And that's because usually the client is at that stage consulting a dispute lawyer who will have an eye to the end game, which is enforcement of your judgment. Rather less of a factor, in my experience, at the earliest stage where a choice is being exercised at the time the commercial contract is being settled on. And I think the reason for that is simply that the people who typically are involved in drafting those arrangements, unless they're very sophisticated, does happen in some cases, but by and large, the factors that drive the choice are rather more the ones that I identified at the beginning of these remarks. Do you have a stable legal system? Do you have a solid and independent judiciary? So overall, will the market be affected? I think it may be, but I'm tempted to think, bearing all those factors in mind, that the difference may be marginal. I'll stop there.
Thanks very much. And David Duss now from Fresh Fields.
Thank you. Thanks. Now for something slightly different. I'm a senior associate in the competition litigation team at Fresh Fields, so I wanted to talk about the impact of Brexit on competition litigation in London, and in particular follow-on damages claims in the city, by which I mean private enforcement, private damages actions follow on from a regulatory decision finding a breach of European or domestic competition law. Now that has been a success story for the London litigation market in recent years, not least to demonstrate by how busy I am, but more importantly by the sheer volume of claims that have been brought in the UK in the High Court and the Competition Appeal Tribunal, and the size of settlements that have been achieved in that space. Rather than sort of give sort of definitive views, I just wanted to sort of lob out some suggestions to provoke some debate. Not least because there are bigger brains in the room than mine, and I reserve the right as a city lawyer not to give a definitive answer on anything. Firstly, potential impact number one. Now, follow-on damages claims have been brought here successfully, in large measure because of the binding nature of European Commission decisions, which the High Court and the Competition Appeal Tribunal will follow. The question then is, post-Brexit, what is going to be the nature of those decisions? In the Norwegian model, if we take that route, Commission decisions will still potentially have some effect because they have EEA relevance. But outside of that, there's a question about what impact those decisions will have. And that has a very practical effect in sort of commercial terms, which is one of the reasons for the growth of litigation in London has been because there's been a proliferation of funding arrangements and funders that have come into the market, such as Burford Capital and Harbour Litigation, and they want to do some things that are cheap and easy, and having a commission decision providing a roadmap means that there's less risk for them in taking on a claim. If these claims have to become standalone claims, will they be disincentivized from bringing those claims in the first place because they're at more risk? Secondly, one of the reasons that London has been home to pan-European claims has been because Article 6.1 of the Brussels Reg has provided a very convenient route for such claims to be brought here through the medium of a UK anchor defendant and then bringing in wider European defendants here. Assuming, and there's obviously been the discussion today about what post-Brexit might look like, we'll have a debate about that, but if we're obliged to fall back on forum convenience rules, etc., that might be a little bit more complex. Thirdly, a techie and practical point that we as city lawyers have been grappling with is privilege. The European case law, AM&S and AXO, says that in the competition context, privilege will only attach to communications from an independent lawyer who is qualified in an EEA state. The UK will not be an EEA state, so will our communications to our clients in competition investigations and in competition litigation be privileged? Arguably not. And I know that there are barristers, etc., and other lawyers, I'm not saying anything about what Freshfield's position is, around the city who are currently getting Irish qualification, just in case. All that being said, is there a risk of overstating the downsides? As Adam said, London is an attractive legal market for a variety of reasons. In the competition context, there are two key drivers that make London an attractive market. One is disclosure, the availability of wide disclosure, which is not common in the rest of Europe and civil jurisdictions. And secondly, it's the possibility of making cost-shifting settlement offers through the medium of Part 36 of the CPR rules, which now have an analogue in Rule 45 of the Competition Appeal Tribunal rules. That is a tactical driver that's used in litigation to great effect. In addition, there are certain UK innovations which have made the City of London an attractive place to bring competition claims. The Competition Appeal Tribunal is a specialist tribunal which has recently been given enhanced powers to fast-track cases, for example, to grant injunctions on special terms. And in particular, last year, the introduction of a limited opt-out class action regime for competition infringements, US-style class actions to some extent, and that is potentially very attractive for claimant firms. Final thoughts, as a civil lawyer, I'm proud to say this: follow the money. Claimant law firms have been setting up in London for a number of years, and that has actually increased in the last year. You've seen companies, American companies like Scott & Scott, open up offices here expressly for the purpose of bringing competition litigation claims. That's with Brexit having been on the horizon, so they must view some prospect of the city still being a centre for competition litigation. Finally, just a technical point potentially, depending on obviously how Brexit is done, I should just say obviously we're assuming it's going to happen, and clearly it's not. But assuming Brexit does happen, clearly there will be some form of transitional arrangement. What that arrangement is obviously speculation at present. But on one view, it will be that for the period of 2 years or whatever of the negotiation process, Commission decisions will still have effect as before. So the question, will that actually lead to a flurry of claims in the short term as people try and take advantage of the window that they have? That's all I have.
Thank you very much. Well, we've had 3 practitioner views, and they've all been extremely to the point, I think. But now Diana Wallace is going to speak from a slightly different point of view. And she's a former Vice President of the European Parliament, no less, and present President of the European Law Institute. So she's going to look at these questions from her point of view. Diana.
Thank you very much. I feel somewhat intimidated, surrounded by city lawyers, having been one once upon a time, a long time ago. But I think I wanted to start, and listening to what we just heard, we have a huge success story here in London. And I was reminded the other day, I travelled back from a meeting in Brussels via Eurostar, and there's a huge hoarding as you go into the passport control, which says, something like, great doing business in Britain, obviously using the Great Britain, and the sectors that it highlights are law and accountancy. So, you know, we're still selling it strongly, and we know that our Law Society and other institutional bodies have done their best over the years to make sure that London has been a success story, and it clearly has, and I'm glad we've had the view about competition law, because it was always my belief that with freedom of movement of judgments, we could do very well from that. But the other thing that comes across to me very clearly this afternoon is this horrible word, uncertainty. Okay, we may have our 2 years of continue as you were, and we may have some very innovative ideas that we've heard about this afternoon about how to get from A to B in a reasonable manner. But I still worry in the sense that the main question that again comes out is this issue of enforceability. And it may be the case that people don't address enforceability when they make commercial contracts, but they should. We all know that they should. And that's the Achilles heel of Brexit in these arrangements. And I think the uncertainty is potentially greater than we realise, because this 2-year period that allows us to get to an agreement, it's an agreement which is merely, according to Article 50, about, quote, the arrangements for the exit and a framework. That means that you've still got a huge space afterwards when the detail of that framework and those arrangements has got to be put into place. So it seems to me you have potentially a very long period of uncertainty. And that to me must be dangerous to what we've created here in London. And I think it goes further than some of the subjects that we've covered today. I think most people in the UK have always sort of said, oh, we quite like the internal market. Well, up against the internal market, Europe has created this space of justice, and it's a coherent space. We can criticise all sorts of bits and pieces of it. And the Brussels I regulation is the bedrock of that space. And you have many other bits and pieces of regulations, directives that build on that as a justice system for Europe and to make the internal market function. And if we unravel that, the very thing I think that many British citizens accepted about Europe, that's the internal market, we put that itself under threat. The other thing that I think we should have at the forefront of our minds is maybe the huge influence that European law has had because of all the positive things we've heard, that English law has had because of all the positive things we've heard on European law and the way that European law has developed. If we draw back, that also becomes questionable. And where does English law develop? Maybe we find our own new space in the world, but it won't be a space with our nearest neighbours. And I think that is the sadness. So excuse me for those rather personal comments, but that's my perspective. And the last thing I would say, don't expect this to be easy. My enduring last memories from the European Parliament were that we had exhausted everybody's patience. It will not be a friendly scenario.
Thank you very much. Well, now we can have some questions, I hope, but maybe, is there a time limit?
I will keep them short, so we can have some questions and then the rest over the
Okay, so perhaps you can, when you want to apply the guillotine, you can indicate.
That guy here who raises the hand.
Okay, already Burkhard. Yeah, okay, Burkhard first, and Thomas second, and Alex third. But Alex, of course, the question can be directed to Alex and to Tanya. So I think Burkhard's now is the first one.
I would like to ask a little bit of provocative question. Adam and Karen, just imagine you have a client who is asking you, should I opt for a jurisdiction clause to Amsterdam or to London? And in Amsterdam, they have experienced judges, they make it in English, they have the knowledge, and they can guarantee enforcement of the title in all Europe. Would you really advise England?
Is that a rhetorical question?
I mean, I think one factor that we haven't really talked about so far is choice of law and how that comes with choice of forum. And so if you've chosen English law as your governing law for your contract, I think I may well still recommend the English courts, subject to the enforcement question. And I think, certainly speaking to colleagues in other jurisdictions, they haven't been entirely negative about the idea that an English judgment as a third state judgment would be enforceable in France, Spain, Italy, Germany. It's possible, it's harder, but it's possible. And as long as it's possible, that may well be enough for our clients.
Well, I think it's a very fair question. And in practice, in the post-Brexit world, it may not be an entirely straightforward question to answer. I think the point that I was making is simply that there are a number of features of the way in which litigation is conducted in this jurisdiction that will continue to be attractive, especially in a case where you have contractual choice of English law. I mentioned some points about the judiciary and certain substantive bodies of law, contract law, tort law and so on, but David, I think, has also drawn attention to the importance of procedural characteristics of the way in which litigation is conducted, things like disclosure, and the way in which trials are managed and so on. And in any given case, it may be that they are significant features that make this jurisdiction an attractive one. But Amsterdam, in other cases, may also be very attractive because they have a much more sophisticated methodology for dealing with aggregated claims than we have. So there may well be instances. And perhaps what the question illustrates is that we all need to be more alive to the possibility of arbitraging differences arising from different ways of managing litigation, different procedural characteristics and so on, that one can now see exhibited across a number of different jurisdictions.
One thing I would add to that in the competition context is that Amsterdam is indeed a very claim-friendly jurisdiction, and my firm has a strong competition presence in Amsterdam too, and so there are claims where there is a choice between whether you go to London or in Amsterdam. And as Alan pointed out, there's the Mass Claims Act in the Netherlands, which can be used as a competition litigation mechanism as well. One of the things that I didn't mention, which I think is relevant to this debate, to your point about sort of procedural arbitrage, is that in a competition context, there's obviously the EU damages directive, which will be coming into force at the end of this year, and that does introduce in the antitrust private enforcement space limited disclosure, etc., into European law, and national member states will be required to introduce that.
Yes.
So some of the advantages that the UK has, they may wither on the vine to some extent. Other jurisdictions may catch up.
And Rome 2, what I remember, it contains some quite interesting provisions on choice of law and competition cases.
Well, that's quite a good example, I think, to bring up Amsterdam. But the Dutch certainly speak English, and they certainly have honest judges and efficient judges. Sweden is another example.
Yeah.
But
it's Germany. I mean, I don't know where this got to. There was talk of a English-speaking German court as well. You've got the rise of a number of jurisdictions that are expressing, Singapore being the obvious one, expressly trying to compete with London. And this Brexit is not a positive for London when you look at that wider context of other jurisdictions trying to take business away from the English courts.
Now, who's the next? I think you were next, weren't you? And then he was third, and then you can be fourth up there, and then probably it'll probably be time for a drink after that. Yes.
Yeah. Throughout this afternoon, I think we had a tendency to compare the existing Brussels regime with the potential regime that some persons would like to have or considered likely after the Brexit. I'm not sure whether this comparison is appropriate at all, for several reasons. It may come worse in the UK than you think, and it is also possible to achieve improvement, although not likely at all stages, but it is possible to achieve improvement in Brussels. For instance, when you look at the development of the regulation, I think it shows that continuous improvement happens. And I could imagine further improvement. I could imagine with more integration, it might be easier to convince the Commission and the Parliament to somehow limit GASA, because I think GASA indeed is an outrage as broadly as it is conceived by the ECJ. It seems very likely that enforceability will be will become even more easily in the future within the European context. The Commission is continuously lobbying to abolish further formalities, to make to limit the exceptions to recognition and enforcement. So what we should compare is what we would like to have here and what we would like to have there. And I have to say that I would be very curious to learn what you think would be necessary to make the Brussels regime even more attractive.
Does anyone want to answer that, or should we move on? Let's move on to Alex.
I just want to make a very brief point, because we've been talking about commercial dispute resolution, but there is another important field, probably in terms of numbers, larger than the numbers that Burkhard Hess mentioned earlier, which is cross-border travel claims. Very large numbers of personal injury claims are brought in this country, or indeed in many other countries, on the basis of the open right decision and the consumer provisions of the Brussels I regulation, whereby the claimant gets their own opportunity to bring direct action against the defendant's insurers when they're injured when they're travelling abroad. And the personal injury bar will tell you that there are lots of lots going on in Britain. It's another result of Brexit. That would stop happening.
Okay, last word up there.
Yes, I was just going to say that in terms of choosing jurisdiction and the benefits of enforcement, obviously banks and financial institutions always concede that there are going to be the claims in any proceedings, and therefore they may be concerned with enforcement. But most parties who agree to jurisdiction clauses don't know whether they're going to be the claimant or the defendant. and therefore lack of enforceability could be a neutral factor if they conceive that they
a non-enforceable jurisdiction agreement.
Yeah. But most parties think they are right.
Yes, that's true. Thank you very much.